The Vice President.
Honorable Minister in the Ministry of Finance.
Thank you, Mr. Vice President. I won't be too much longer. I just have a couple more additional points to deal with. So I was on the issue of extending the period given to the controller to adjust assessments. So, Mr. Vice President, the legislation gives the authority to the officer who is handling the importation to assess the value of the goods and allow them entry based on that assessment. Now, there are any number of things that could influence that process on a particular day, especially when you have an officer who's dealing with high volume, rapid pace, demands by importers to get these things addressed quickly. So that the legislation quite reasonably gives the controller the power to review this in a calmer atmosphere and determine whether an adjustment should be made to the assessment that was raised by the officer. And what we are saying is that having regard to the circumstances, it is reasonable to extend the period that the controller may exercise that authority from the 1 year that currently exists to 6 years. It is coterminous with the period given to the board, as I said, to make adjustments. And we must remember that during this period, the controller, the importer has had use of this imported item, has probably sold or manufactured or whatever he's done in relation to it, has withheld from the coffers of the government for this period taxes that are properly due to the government. So having regard to that, Mr. Vice President, we think that the provision that is being proposed is quite reasonable and we highly recommend it. Senator Mark raised the concern about what he considers to be an unreasonable approach that allows the controller to deprive an importer of the ability to get access to his goods. If an additional assessment is raised, no appeal is filed in respect to that assessment, then the controller can say, well, any further imports that you are seeking to bring in will not be allowed in. Now, Mr. Vice President, if you put this in context, you have somebody who has brought in goods into Trinidad and Tobago, has underdeclared the value of those goods, has deprived the government of taxes properly due to the government, has been assessed to additional duties, has had 6 months during which he can determine, yes, I will challenge this assessment, or no, I will not challenge the assessment. And he fails to do that. In those circumstances, isn't it proper for the controller to take the necessary action to collect the taxes that have been outstanding? And in that context, it cannot be said to be unreasonable that the controller at that point can say, until you settle the taxes that are outstanding, that have been outstanding for some time, that you are probably aware were outstanding because you are the person who understated the value of the goods, that you cannot just continue to import goods at will until you settle those outstanding taxes. There's nothing to me that is unreasonable about that. Senator Mahabir suggested that we would wish to adjust the language somewhat to say that the controller may withhold the goods if no appeal is filed before the Tax Appeal Board without just cause. Now, my concern about making an amendment like that is that you place a burden on the controller to satisfy himself that the importer did not have a just cause before he can act. I think the burden is properly placed on the importer to, if he has a just cause, to bring it to the attention of the controller. And therefore, I would, with respect, not recommend that we go with the amendment suggested by Senator Mahabir, because the importer does have 6 months to bring an appeal if he has a problem with the assessment, and in my view that is more than adequate time. It certainly is more time than a taxpayer objecting to a normal assessment by the Board of Inland Revenue has to bring it to the Tax Appeal Board. 6 months to me is more than enough time, and this is 6 months from his receiving notification of the adjustment. And in the event that the controller is found to act arbitrarily, I'm sure the very importer can challenge the decision of the controller before the court. But to put the burden on the controller to satisfy himself that the importer does not have just cause before he can act, it seems to me, is hindering the controller unnecessarily in the fulfillment of his duties. So I would recommend that we stay clear of that proposed adjustment. The further amendment that is being proposed to the Customs Act is to give the Customs and Excise Division the power to request documentation in respect, greater power to request documentation in respect of importation and exportation. The period in respect of which a request can be made is being extended from 3 to 6 years. And the burden to keep books and records for the period of 6 years is being placed on the range of people who are generally engaged in the process of importation and exportation. These include the importer-exporter, the agent, the customs broker, the warehouse keeper, the port or transit shed officer. And there is a relatively significant offense for failure to collect. Again, Mr. Vice President, I would recommend that we move forward with this adjustment. It is reasonable in the circumstances. The person who has knowledge of the true value of the items and the nature of the items imported is the exporter, and those persons acting on his behalf, and those persons who have temporary control of the goods during the process of importation. So it is reasonable to give the controller a reasonable chance to collect the correct amount of duty, to put the onus on these people to keep proper books and records for a reasonable time, to give the controller the time to do his assessments and due diligence and determine whether he has been collecting the correct amount of funds. So, Mr. Vice President, these are essentially the provisions that deal with the tax issues related to this mutual offences bill, and the ones, of course, on which I'm particularly focused. I think it is generally appreciated that Trinidad and Tobago is significantly under-collecting the taxes that are properly due to the country. We have a $10 billion deficit, and if we were to collect the taxes, even that have been identified in Professor Theodore's report of last year, that deficit would be wiped out. We would not need to borrow from wherever. We would not need to spend huge amounts in interest. People will not be concerned about the fact that we're moving closer and closer to the IMF, perhaps. So it is incumbent on us, if we want to be a self-sufficient country, if we want to return to prosperity, if we want growth and development, that we get the power that we need to collect the taxes that are out there that are properly due to the government, and that are due more from the people who can most afford these taxes. The people who bear the burden of the taxes in Trinidad and Tobago tend to be the people who are least able to afford it because they're the salaried people who have very little option in avoiding taxes. So we want the power to go after the people who have the real funds that are due to the government, and these provisions will allow us, take us some way in getting us to that point. So, Mr. Vice President, on those grounds, I recommend to the Senate that we accept the amendments that are proposed, the bill that is before us currently, and I thank you, sir.
Senator Ameen.
Thank you very much. Mr. Vice President, it is with humility that I arise today to contribute to this debate on a bill entitled An Act to Amend the Mutual Assistance in Criminal Matters Act, the Proceeds of Crime Act, the Financial Intelligence Unit of Trinidad and Tobago Act, the Customs Act, and the Exchange Control Act. I say with humility because I get the feeling today in this debate that we should have some sense of collaboration, because from the onset and from the speakers who have gone before me, I think members of every bench thus far, the opposition, the government, and the independent, have indicated their support in principle for the government's ability to deal with criminal matters as it pertains to the acts listed. So to begin on that positive note, Mr. Vice President, and to reiterate the opposition support for the principles of transparency and good governance as it relates to these matters, I want to remind the members that all of the acts listed today for amendments are by and large the creature of previous UNC administrations who initiated, implemented, put them into law, played a major part into these becoming law. In fact, the record will show that during the term of the United National Congress, the terms of the UNC under the first government, Mr. Bastio Pandey, from 1995 to 2001, and then under Mrs. Kamala Persad-Bissessar as Prime Minister from 2010 to 2015, we saw a number of pieces of legislation, major legislations and institutions coming into being to deal with increased transparency, to deal with money laundering, to deal with financing of terrorism, illicit money, proceeds of crime coming into being. So in addition to the 5 being mentioned today, there are some other examples: the Integrity in Public Life Act, the Judicial Review Act, the Equal Opportunities Act, the Freedom of Information Act, the procurement legislation. All of these are major pieces of legislation which I think contributed positively to governance in Trinidad and Tobago and that were brought by the UNC government. The general principles in the original pieces of legislation are noble, and any reasonable citizen or member of this House would not be against strengthening the state's ability to implement these principles into governance and giving the state greater ability to enforce those laws. In asking the Senate to consider these amendments, I must say that compared to what happened in the lower house, today the Attorney General gave a lot of explanation and a lot of justification as to why the government felt the need to bring these measures. I think it's important for us to consider the shortcomings of the existing legislation as encountered by those agencies who have responsibility for its enforcement. We must weigh the good intention against the reality of the impact, what really happens on the ground, what happens within those institutions, what are their hurdles. And how will the legislation improve and strengthen on their ability to enforce the law? But, Mr. Vice President, we must be careful in going after any type of criminal activity, whether it is violent crime, white-collar crime, that we are not placing a noose today that could be tightened tomorrow around the neck of the rights of citizens, which is guaranteed and protected in the Constitution. We must balance going after the lawbreakers with protecting the rights of our citizens. And that, Mr. Vice President, is one of the concerns that I have, which I will come to a little later. When we create legislation, I mean, many times in debates, we talk about the fact that we must give consideration to every possible scenario, that we don't make laws only for today, we make laws for the next generation, we must presume, the worst could happen. And, Mr. Vice President, I want to say from the onstart that I am presuming nothing except the most impeccable and noble intent by the current government. But we must be careful that we are not opening doors for future government, future holders of high office, whether it is in government or within the enforcement agencies, for there to be any form of malicious prosecution, for there to be discrimination, inequality, abuse of power of any kind, and witch hunting. It is easy, Mr. Vice President, to use phrases such as follow the money. You talk about, you stereotype people who have gold chains around their neck to show that you are not only going after one class of people, but in fact, many of the people who strongly advocate, and, well, I shouldn't use the word advocate, but they talk about finding the perpetrators and dealing with people who benefit from the proceeds of crime. They themselves are benefits of the proceeds of crime. They are themselves are benefits of ill-gotten gains, and the phrases that they use to constantly engage in that political attack on their opponents, it defeats the purpose that we are here for today. Mr. Vice President, what we should be looking at today is the ability of the Financial Intelligence Unit, the Director of Public Prosecutions, and the judiciary to deal adequately with the matters of money laundering, illicit money, and proceeds of crime act before them. Clause 2 of the bill proposes to remove one of the many powers granted to the central authority by deleting Section 22(2)(k) of the Act, which empowers the authority to refuse a request that relates to a criminal offense under the tax laws of a Commonwealth country. And that section states that a request for assistance under the Act duly made by a Commonwealth country shall be refused if, in the opinion of the central authority, the request relates to a criminal offense under the tax laws of a Commonwealth country, save that the assistance may be granted if the offense is committed by way of an intentionally incorrect statement, whether oral or written, or by a way of an intentional failure to declare income derived from any other offense covered by the Inter-American Convention on Mutual Assistance in Criminal Matters. Mr. Vice President, for the benefit of the members of the public following our debate, mutual assistance is that process which countries use to obtain government-to-government assistance in criminal investigations and prosecutions. This type of government-to-government collaboration and assistance can be used to identify and to recover proceeds of crime. We always hear of stories of offshore accounting where people bank their monies in different countries. And while there are countries who have very strict and very robust taxation systems, there are people who also try to evade taxation by banking their monies in different countries. All of our requests, all requests for extradition and for mutual assistance, that government-to-government assistance, is made to our country, to Trinidad and Tobago, are coordinated by the Central Authority Unit, which is a part of the Office of the Attorney General. The unit plays a very key role in the foreign and local authorities obtaining to obtain persons, when persons seek to get to sever their sentence and so on, and any sort of relation they have with extradition. But the unit only deals with requests for assistance in criminal cases, but they are also responsible for sharing confiscated, forfeited, or seized assets with other countries, returning the money to the rightful owner. The negotiation of mutual legal assistance agreements, international cooperation agreements, and other treaties with other countries. My question surrounding this amendment, it has to do with the sovereignty of Trinidad and Tobago as a republic. How does this removing that discretion that we now have, to me, it affects the sovereignty of our government, of our state. The state has a duty to protect its citizens. And I want to be very careful that my words are not twisted or misinterpreted, that the government should protect criminal citizens or wrongdoers from facing justice. It is very possible for a citizen of Trinidad and Tobago to face malicious prosecution from another government, from another country. People go to other countries, and because of their volatile political situations, people get involved in political movements, social movements, civil unrest movements, and can become a target of another government. I'm just creating a scenario, Mr. Vice President. If we strip ourselves as a state of the ability to protect our own citizen from a foreign power, we are losing or giving up on our ability, not our ability, but our responsibility as a government to protect our citizens. I know the Attorney General mentioned that there is the requirement in justifying that removal. He indicated that there is a requirement from the regional, the CFATF, but Mr. Vice President, I beg to differ. There are other countries in this region who are part of the agreement, who have similar governance models to Trinidad and Tobago, who have retained that ability to protect their citizens. And all it does is give the state the power of discretion. So if the authority believes that its citizen is involved in wrongdoing, or is in fact the investigation or the request for information is justified, then by all means you proceed with enforcing the law and cooperating with the foreign authority. But in the event, if perchance a citizen of Trinidad and Tobago is a victim of malicious prosecution by any foreign government, we must have that power of discretion to protect our citizens. And this is a matter that I think we need to give closer consideration to. I am asking, what is the advantage? What advantage does it create for us, Trinidad and Tobago, to surrender that power of discretion that the central authority now has by deleting this clause from the Mutual Assistance in Criminal Matters Act? Mr. Vice President, I also had some concerns concerning Clause 3 of the bill, which proposes to simplify the prosecution of the offense of money laundering in 2 steps. It would no longer be an indictable offense, and thereby, of course, you must delete Section 44(2), and by making the offense triable on both summary conviction and on indictment. Mr. Vice President, while the statement the bill proposes to simplify the prosecution of the offense of money laundering is laudable. My question has to do with my question, Mr. Vice President, has to do with the previous statements by my first question has to do with the judiciary's ability to deal with the cases before it. The Attorney General indicated that many of these cases take a number of years to come to an end. Well, many criminal cases take a long time to come to an end. In fact, almost every type of case in the courts at present take a very long time. I don't recall the judiciary or the Chief Justice in his statement, his annual statement at the beginning of the law term or at any other time, indicating that they have encountered challenges with efficiently dealing with these types of cases. While I agree that you would want to speed up justice, in fact, every sort of wrongdoing, every matter that goes to the court, you would want to increase the efficiency of the court. I am asking if to simplify the prosecution of money laundering is, it sounds like a simplistic sort of solution. And I think it's important for us not to compromise justice and a fair trial. Of course, there's a presumption of innocence until proven guilty, but the fact is, once a person is accused, they are in the court of public opinion guilty. And we have had a number of persons in public office as well as in the business sector, in the private sector, who would have been involved or rather charged with these type of criminal activities. And from the moment they are charged in the public opinion, their reputation goes to zero. It affects their ability to earn a living, and in fact, it affects their family. And we have seen cases, I recall a former government minister where 12 years after he was charged, the case came to an end and he was freed. So these are things that I am in principle in support of, improving the amount of time that it takes to settle these matters, not only money laundering and white-collar crime, but all matters, because I also know of young people who would have gotten into trouble with the law at the age of 19, and at 36, at age 36, the matter is still before the court, and it affects their ability to apply for jobs and so on. So it goes across the board, but when you take it to the magistrates, how much more efficiency do you anticipate? Has the judiciary been involved? Have they been consulted? Have they identified this as a major issue? We have had trial by judge and jury. We have had discussions here, debates here about trial by judge alone. And I understand the trust to improve the efficiency of the judiciary. But we also must, Mr. Vice President, improve the capacity of the DPP as the Director of Prosecution and the Financial Intelligence Unit to ensure that the prosecution is strong, because many of these cases stay very long in the court, yes, even if they are resolved quickly. But I think if the prosecution has greater capacity in terms of case preparation, in terms of case management, the accommodation, not only to store documents, but to comfortably house well-qualified, adequate staff. Their infrastructure, there were some matters revealed when the DPP came before our Joint Select Committee with regards to their ability to effectively do their work. Do we really truly get justice in a flawed system, even with the best intent? So I think those are matters for us to consider, and I want to support the call by Senator Mark with regards to our Joint Select Committee on this matter, because I think it's important for us to bring persons from these various agencies before the committee, before the to get their input and their recommendations firsthand. Because as I said, in principle, the opposition is in support. In fact, because we piloted a lot of these legislation, the parent legislation was brought by the UNC when we were in government. Mr. Vice President, the other point I wanted to mention was the Financial Intelligence Unit. The Financial Intelligence Unit of Trinidad and Tobago is another example of good law that was passed by a former UNC administration, and it establishes the Financial Intelligence Unit of Trinidad and Tobago, and further it implements the recommendations of the Financial Action Task Force on Money Laundering and the Financing of Terrorism. Mr. Vice President, recently the word financing of terrorism has become a sort of catchphrase, and I want to say that while I agree that with the idea of ensuring that we have continued collection of financial intelligence from banks, from other financial institutions, Mr. Vice President, we also, the amendment gives the FIU, is seeking to give the FIU the ability to investigate any person on its own motion. While that is commendable in terms of giving them more power, at present, the FIU would investigate matters where, for instance, a financial institution flags a suspicious transaction, and they bring it to the attention of the FIU. Giving them the ability to now investigate on their own motion, I think it must have some conditions. There must be some conditions. So what triggers this investigation? A person could be called in to be asked some questions and believing that, well, I ain't do nothing wrong. And you go and you end up becoming involved in something that is much bigger than you. So I think it's important for us to have some discussion as to what could be some of the triggers. What could be some of the triggers? What formal mechanisms we could put in place in terms of conditions to justify the FIU beginning that investigation on its own motion. Again, the protection of citizens and the rights of citizens, I think, is also important to balance. But by all means, I am in support in principle of the Financial Intelligence Unit continuing its work to ensure that improper movement of money is monitored and dealt with by the state and the authority. One of the other things, I know the Attorney General mentioned the latest report of the Financial Intelligence Unit, and I wanted to ask, there were some recommendations. I was just looking for it, but Mr. Vice President, I recall reading it. I'm not sure if it was in that 2017 report, because I did also read that report. And basically, there are some shortcomings that the FIU would have identified that prevented them from doing more in terms of prosecution. And we ought to look at those to make reasonable recommendations to include in law. The principles in this, I think, is sort of similar to what we had discussed in FATCA, where you can have that sort of malicious prosecution, political victimization, discrimination taking place, the possibility that that could happen. It may not be under the current director, it may not be under the current government, but we must protect our citizens by putting good law in place. The violation of human rights, privacy, must be balanced with strengthening the institution, and if we want to give them more powers. Mr. Vice President, when it comes to anything, of course, that tramples on the rights, the question now arises as to whether we need a simple majority or we need a special majority to deal with this, this particular part that may have some impact on the rights of citizens. So that is something I want to consider. My other point I wanted to mention has to do with the, that is the clause 5 of the bill, which seeks to amend the section 23 with the addition of a new subsection that gives the comptroller of account, the comptroller of customs, the power to refuse entry or delivery of subsequent shipments of an importer where an adjustment is made to the value of his goods and he has not paid the adjustment and fails to commence proceedings before the appeal board within 6 months of the date of notification. Mr. Vice President, I listened to the previous speaker, Minister in the Ministry of Finance, Mr. Honorable Allyson West, speak about customs and its ability as an income generator for Trinidad and Tobago. But like the license office, comptroller of accounts is probably the, I don't know which is worse in terms of allegations of wrongdoing by public officers who are supposed to protect the interest of Trinidad and Tobago. And there are many instances where importers have no choice but to engage in these activities if they want their business to survive. The powers given to the comptroller of accounts are delegated to officers who conduct their day-to-day duties. My concern, Mr. Vice President, is the abuse of power that presently takes place within customs. That is very rampant, and I'm not afraid to say so. And any person who has had to even collect a barrel from their grandmother know about these things. If somebody sends on a barrel and you have to go to customs. But Mr. Vice President, on a bigger level, there are businessmen who import goods on a weekly, on a daily basis. And there has been a lot of opportunities and actual abuse, instances of abuse of power. And that is what I think we have to guard against. In my view, this sort of gives the officers, the corrupt element within the Customs Department, the opportunity to push the importers further against a wall. This, Mr. Vice President, could be another tool that they use as a sort of, to hold you to ransom. So in the instance where you are asked to pay some sort of bribe to allow your goods to come in, and you don't participate with them or give them the money that they ask for, they could use this power to hold you to ransom. And even now, without this, they do it. So, Mr. Vice President, there is, I think it's common knowledge that there is a cartel. There are people who operate, and I want to be very clear, there is a corrupt element. That does not mean that every customs officer is corrupt. That does not, I'm not casting any aspersions on the comptroller of customs. I'm saying that his powers could be delegated to any officer. And I think it is public knowledge in Trinidad and Tobago that there are corrupt elements within that, within customs who could abuse the further powers being given. So, Mr. President, Mr. Vice President, we must ensure that there are mechanisms to prevent that sort of collusion. Well, Senator Mark mentioned the legislation with regards to the clerks and customs brokers, so I wouldn't repeat that. But certainly that, that undue influence for business alliances and conglomerates to be involved in that cartel, as I called it earlier. Mr. Vice President, I just want to reiterate that I am not casting any aspersions on the whole of any office within that or any other body in our country in this debate. Mr. Vice President, I just wanted to add a point made by Senator, I think it was Senator Mahabir, with regards to the central bank exchange control. There are already very extensive controls that exist in terms of state apparatus. And I don't see why, the need for me, perhaps other speakers on the government side may explain a little more, but I think it's there's no need for that sort of interference. We have standards from the central bank, and I think if we let them operate to their standards, there is no need for this level of intervention. My question with regards to this: how many corrupt criminals will this new amendment catch? What effectively are we difference are we trying to make? How will law enforcement be further empowered when it comes to prosecution? Those are things that neither of these two speakers before me on the government side mentioned, but I'm sure that hopefully someone else may. Mr. Vice President, there was also the part with regards to the value. Well, Senator Mahabir made that point. I don't want to repeat, but just to indicate that 20,000 TT is close to $2,800 US. The rate fluctuates. Even now we don't have an official rate, but I too agree that we should give consideration for having something similar to the 10,000 US. The value should be similar in terms of 60 to 65,000 TT, which will be more in line with the US and the Canadian amounts. We must ensure that we are not putting, while we are protecting we want to protect from wrongdoers and fraud and money laundering, that we are not in fact putting measures in place that will be a deterrent for legitimate earners to come to Trinidad and bring their money and spend their money in Trinidad. So that is something that I think we have to balance. So, Mr. Vice President, while the Attorney General indicate that this bill is simple, there are, in my view, there are some implications for the rights enshrined in the Constitution, but some implications with regards to the sovereignty of our nation, and I think we have to balance the power of the state in this function, and to keep our nation as a functioning democracy, we must be able to continue to strengthen. And I want to say that the Attorney General spoke about the FIU's record in terms of implementation and prosecution, and he indicated that the increased number of cases mentioned meant that the FIU was more efficient in terms of finding wrongdoers. And, Senator Mark indicated that it may just mean that there are more wrongdoers during the PNM terms in office. But whether that is either one is correct, the fact is that any legislation that deals with white-collar crime, and in fact crime on a whole, must be strengthened government to government. It is, in my view, it should not be a competition as to who did what. We must each, in our time in office, because no person sits as Attorney General forever or Prime Minister forever, we must ensure that whatever we add or contribute benefits the nation in the long run. And so as we treat with this issue of criminality across borders, of improving our ability to collaborate with international bodies and other governments, I want us to keep the best interest of the citizens of Trinidad and Tobago in mind. With those words, Mr. Vice President, I thank you for the opportunity to come.
Thank you very much, Mr. Vice President, for giving me the opportunity to join in the debate on this bill that seeks to amend several pieces of legislation, the Mutual Assistance in Criminal Matters Act, Proceeds of Crime Act, the FIU Act, the Customs Act, and the Exchange Control Act. Mr. Vice President, I noted very well in the AG's presentation this afternoon, he made a key statement that I totally subscribe to, that Trinidad and Tobago finds itself in globally tumultuous times. Mr. Vice President, in looking at where we are as a country, one of the things that I always advance is that in terms of trying to fix a problem, the first stage in fixing a problem is acknowledging that there's a problem, and then acknowledging the scale of it. Not just saying there's a problem, but acknowledging the full extent of the problem. Mr. Vice President, if you'd permit me, before I go into the introduction to my presentation, I want to quote from an article in today's Express, written by Ricky Ramdas, and he's quoting from a judicial officer who gave a ruling, and I want to quote. It says, "This society is plagued with the disturbing reality that prohibited goods, which include narcotics and firearms, are imported with impunity. These prohibited items do not fall from the sky, and the reasonable inference is that they are either smuggled through porous areas along the nation's coastline, or they are allowed in by complicit and or complacent officials who fail to refuse or detect same," and it goes on. Mr. Vice President, I'm a normal, regular person. I like to acknowledge the reality of the situation, because let's not put sugar on it. We have serious problems in this country that needs us to really focus and try to find, and everything may not be perfect. I'm on record here, Mr. Vice President, as saying several times, I will accept a 70% solution because it allows us to move forward. We will never get everything right the first time. And even after multiple attempts, it still may not be perfect, but we need to move in that direction. Mr. Vice President, I'm just one person here today, and I have the privilege of being able to come to this chamber and be able to contribute. And I think that one of the things the first thing I want to talk about is the fact that this bill is an omnibus bill. And advocates of our omnibus bills will argue that the packaging of multiple amendments and provisions allows for greater legislative efficiency and perhaps enhances the chances of a bill being able to be successful. The challenges of omnibus-type legislation will also argue that it potentially denies members of the legislature of the ability to thoroughly examine all of the individual pieces of provisions. I believe there's merit in both arguments. And I think what the reality of where we are with the way in which the Parliament, as we are currently structured, works, omnibus bills are probably one of the ways in which you'll really only get things moving in a reasonable time frame. So while I'm not necessarily enamored of sitting at home with 4 or 5 volumes of the laws of Trinidad and Tobago, trying to look at the amendments and then have all of the parent acts in the various volumes, it's part of the job. Rather than be looking at one act, you're looking at 4 or 5 parent acts to try to understand what we're doing. And it adds a layer of complexity to the work that we're doing. And I think from the view of the small man in the street, Mr. Vice President, I think that is where my concern is. For the average normal person like myself, listening to these debates, if we were talking about one issue, sometimes it could get very complicated. When we're talking about multiple issues subsumed within one bill, I think that it adds a level of ambiguity to those who are not legally trained, who don't understand the legislative system and process. And I want to put that on the record. And I'm not saying it's wrong, I'm just saying that is what it is. And all that does, Mr. Vice President, it places pressure on us, certainly people in my particular experience, to be laser focused and to be very clear about what we're doing here, because these things have impacts. Mr. Vice President, I want to say that this bill the first issue has to do with the Mutual Assistance in Criminal Matters Act. And that was a bill, when it was passed to deal with the increasing levels of transnational organized crime, and it allowed for the facilitation of cooperation for the apprehension of criminals. Given the crime situation in the country now, in all honesty, we need all the help we could get. I'm on the record here, Mr. Vice President, as saying that crime is out of control in this country. And that white-collar crime, well, that doesn't exist. Because as far as I'm concerned, or what I have seen, it doesn't exist. So there's no white-collar crime. Trinidad, Mr. Vice President, if you check the records, and I think you should, with the greatest of respect, Trinidad and Tobago is likely to make this year's edition of the Guinness World Book of Records for having the longest running stock exchange that has yet to proffer a matter for prosecution for insider trading or any type of offense whatsoever. The Trinidad and Tobago Stock Exchange should be held out as an exemplar for other stock exchanges around the world to follow. Mr. Vice President, financial fraud, money laundering is more than rampant in this country. When I speak to the amendments that have been proposed affecting the FIU Act, the shocking details of the extent to which our financial system is being used and manipulated for illegal activity is utterly mind-boggling. So when we sit here and we talk about $22 billion, perhaps for me, that's $22,000 million. I am trying to figure out 22,000 is a lot of money for me. What persons or what ilk of persons are able to try to move around $22 billion in this economy in 12 months? What are you doing? What are you doing? Mr. Vice President, the history of this country is replete with examples. CLICO, HCU, FCB, IPO, all sorts of people doing all sorts of things. And not a man has made a jail as yet. They didn't even reach the courthouse. Mr. Vice President, I'm a realist. I've accepted. I have accepted that, at least in my lifetime, that nobody will ever make a jail for these scandalous acts that have raped and pillaged the economy of this country, whilst critically reducing the opportunity for regular citizens of this country. The rich are getting richer and fatter, and the poor are being squeezed and squeezed and squeezed. The bill before us, Mr. Vice President, also proposes amendments to the Customs Act and the Exchange Control Act. Given that these areas have been a long time under suspicion, for being a route for the transmission of criminal activities and criminal proceeds, these are provisions in here that I have one or two things to say about, but I support. Mr. Vice President, on many occasions in this chamber, and I believe in the other place, the words discrimination, nepotism, and corruption have been mentioned in many contexts. However, I believe that in the vast majority of the situations in the past, there's one piece missing. And that had to do with the punishment for those allegedly performing such acts. Mr. Vice President, until someone cuts a jail for these, we are destined to repeat. All of these things are destined to be repeated. That's just the nature of it. Because when you have a situation when people can do things with impunity and no penalty is being applied, the daily ongoing banditry by the banks, it will never change, but I will keep talking about it. Daily banditry, the hustling of the citizens of this country are being held to hostage by the banking sector. And what? David Small talks about it. my good colleague, Minister, my colleague, Senator across there, is having a laugh at it, but I mean, that's the reality. And I will talk about it. Because, Mr. Vice President, in Trinidad and Tobago, nobody really cares. Because if somebody really cared, I believe somebody would have done something. I believe nobody really cares. Mr. Vice President, Clause 2 of the bill is the Mutual Assistance in Criminal Matters Act. I think that is something that is critical to protecting our country, because the way in which things are happening in this country, information, the sharing of information, and the ability of the police in arms and all the state security arms to get information that may be very difficult to get. Otherwise, it's something that is absolutely critical. The amendment before us allows for broadening or removing some of the structures around the information that can be shared. And the premise of this, in my view, Mr. Vice President, is that the fact that criminals continue to evolve in the way in which they do what they do. And they use other jurisdictions to flee or hide to flee to or to hide their ill-gotten gains. So I support the opportunity to widen the information that can be shared under this arrangement. And I understand there may be some concerns. But Trinidad and Tobago does not exist in a vacuum. You know, Mr. Vice President, I recall I was one of those persons who would always advocate follow the money, because I believe that that's how we catch people. And it's not just a statement out in the air. There's a former U.S. Attorney General called Loretta Lynch. She also used that phrase a lot. And she used it to the good effect. Some very good people in some very big places in a whole international organization have felt the effect of a concerted effort to follow the money. It works. It works. And it can work. Mr. Vice President, I think that the Proceeds of Crime Act is clause 3. And a key effect of the clause, the amendment, is to increase the penalties for those found liable for holding criminal property. And I suppose in some contexts, it simplifies the process. I would like to see that process is used to go after the $22 billion people. The people who are trying to use the effort, use all our finance, go after them. Because the man in the street, like me, has nothing to fear. Why I don't have $1 billion to funnel through the system? Okay, the man in the street who's living month to month has nothing to fear from this. That is my respectful position. The man in the street who's working every day, struggling to make ends meet, is lucky to have $2,000, much less for $2 billion. So the people who are able to manipulate the system and have billions of dollars to transmit through the system, those are the ones who need to be able to say, oh, perhaps somebody's trying to do something. The man in the street, like me, I am unconcerned. I have zero concerns about this because I have no money to funnel to go anywhere. I'm trying to keep my kids in school and keep my head out of trouble. Yeah? So, but I believe, Mr. Vice President, I've advocated to the Attorney General also that I recall there's, in the United Kingdom, there's a special police unit that conducts investigations. And what they do, they turn up at your door. They conduct the investigations, they turn up on the door, hello, UK Police Force. And then they say, all of the things that are in your possession, could you demonstrate that you obtain these items legally? Failure to satisfy them means arrest, forfeiture the items, and public auction of the items. There's BBC has a TV, so you can find it on YouTube. It's called Ill-Gotten Gains. It's a remarkable effort by the UK police to go after people who have shown themselves to be living a lifestyle, living a lifestyle that their legal earnings cannot support. They look at the records, you're supposed to be earning this much, you have a yacht, you have 2 Bentleys, there's no way you could be living this lifestyle legally. And if you can't prove that you earned that money legally, so I've heard the Honorable Attorney General say that type of legislation is coming. I am looking forward to it because I believe that is one of the things we have to address. And I think one of the key things is that the burden of proof in that particular setup is on the party who's accused. The police are just say, here, we have the information, you prove it. If you can't prove it to our satisfaction. So let's see how that works. Mr. Vice President, I also am very clear, and I've said it again, and I keep repeating myself. Persons who are involved in crime are not involved in crime for being involved in crime. They're involved in crime for the proceeds, the things that they get from crime. That's what they're in crime for. And Mr. Vice President, we have to be real about what is going on in Trinidad and Tobago now. There are people who, just like you and I may get up in the morning, go for a sweat in the gym or whatever, and get organized and get to work. Their whole objective, the plan for the day and the week is what is the crime I'm going to commit today or the crime I'm going to commit. They have no other activity than crime. That is their whole activity, nothing else. And the problem that we have as a society, Mr. Vice President, is that the family and friends of these persons are in fact active accessories to this crime. And it's a societal problem. I don't have a thought about how we can immediately fix that. But when you live in a situation where you know a family member or friend is providing you with money or food or whatever, and they're getting it from crime, that is a societal problem that we have to target and we have to tackle. Because what we end up with, Mr. Vice President, is the proverbial good boy explanation. He was a good boy. He provided. Yeah? Yeah? And I don't know when we're going to get Mr. Vice President, for the record. I was born in Rose Hill. For the few people in here who know where Rose Hill is up the street, so up on Israel River. So I tell people about being, I don't want to hear about this victim of circumstances. That doesn't work for me. Yeah, I don't accept it. I don't subscribe to it in any way. I had the most thing that I had in my household. My mother is a saint. Bless her heart, she's still alive. My father passed. We had a lot of love in the house. I get plenty licks as a little boy to get inside the house before 6 o'clock and try to do your schoolwork and try to hold your road straight. As the old people used to say, hold your road straight. You go in here, go straight there and come back. So people who want to claim that they have challenges about a victim of circumstances, I don't support that. Because there were lots of things happening in circumstances where I was growing up, and I held my road straight. So don't blame other people for your weaknesses and your feelings. So, forgive me for digressing, Mr. Vice President. Criminal property, Mr. Vice President. I think that one of the things that I always remember that one of the biggest pieces of criminal property in this country was something called diesel. People didn't understand that criminal diesel from Trinidad and Tobago's petroleum refinery was being sold on the high seas. Yeah, selling at $1.50 at the point, and then guys were selling it. I mean, the extent to which people have been creative with crime in this country is amazing. It's amazing. And these are not hijackers. These are guys in white collars who've worked out their way to defraud the state and the people of Trinidad and Tobago. And that's what they're dealing with. So, Madam President, welcome. It's always a pleasure. I apologize for starting without you. Yeah. If you know, Madam President, forgive me. You know, I'm well behaved. I very rarely give trouble. Madam President, I am in the midst of warming up. So that the clause 4, the FIU Act. Again, I looked at the amendments in here, and I support them because the FIU is a tremendous resource, Madam President. And things happen in Trinidad and Tobago that very few people pay attention to. And when some guy in the Senate here asks questions, the silence is deafening, so I just leave it alone. I could only ask questions. So, Madam President, the FIU prepares a quarterly suspicious transaction report. And in the early life of this report, the quarterly reports were unremarkable. In particular, the suspicious activity in US dollar transactions was 1.2 million in a quarter, 2.7 million in a quarter, 1.0, 595,000 US in a quarter. However, in a quarter, in the period April to June 2014, that particular quarter, the STR report showed 32 million US dollars in suspicious transactions. It's only a pure coincidence, Madam President, that was the same quarter in which the way in which foreign exchange was being distributed in this country was adjusted. And I am not a conspiracy theorist, Madam President. I just ask a question. If all along the previous reports were going in one particular direction, and then in one quarter, immediately as the controls, the way in which foreign exchange was distributed by the banks was changed, that is the quarter you saw a virtual tenfold increase in suspicious transactions. I'm just looking at the data, and the data suggests to me that something went awry. But I have no real explanation for it other than to say I like the data, and I support the work in which the FIA is doing, and I support many of the actions that we're taking here in terms of the way in which the amendments have been worded, because several of them have provided for cleaner, stronger language, have increased the flexibility of the FIU, and I think that the particular clause where it says, I think it's clause 4.1b, Roman 3, where the FIU may, upon its own motion, upon request. I think this is important because it allows them to be able to act in real time. I think that the issue with crime is that we have to understand that crime and criminals, the way in which they do things, keeps evolving, they keep improving. And given the FIU the ability to adjust and be flexible in real time is important. I also believe that the clause 4.1e, where it strengthens the enforcement and evidence gathering capability. And I support that. Yes, Madam President, I'm running quickly here, because the bill is quite involved. I will not be able to cover all the areas because it's just a lot of issues inside of there. I now go to clause 5, Madam President, the Customs Act. I looked at this particular clause, and I don't want to repeat some of the things that people have spoken about because I have some of the similar concerns. But I have a question that I would like to address. Let me get to the correct section of the Act. Right. Where it speaks to, let me see, Customs Act is amended. I think the section where the subsection relates to firearms accessories shall not apply to a holder of a firearm user's license under the Firearms Act. And this has to do with the ability to bring in accessories. I am asking the question, if you are a licensed firearm user and you have one firearm, does it mean that you could bring in unlimited holsters and scopes and other things? I am not sure. So that I understand why in the thinking, in the drafting, you said that the ability to bring in accessories should you allow firearm users, licenses holders to be exempt from that. But I'm saying if you should exempt it to one. Yeah? Rather than I am a holder of a firearm user's license, I bring in 10 scoops, I bring in 10 holsters. So I think that there's something in there that probably could use some tighten up if the government is looking at it. Because I believe it should have a qualification or a limitation. If you have 2 firearms, you should only be able to bring in 2 sets of accessories per 3 years or whatever, something along those lines. Some kind of limitation. How it is open-ended here. So what it means, I can go to the order what I want, show the authorities my firearms user's license, and bring in a whole container of accessories. Because there's no limitation as it's currently structured here. All right. I had a couple other little things, nothing too major, because I believe also that the issue where this whole issue of trying to make sure that our customs system is tighter, I think we have to accept that at least parts of this system is broken. And unlike the colleague before me, Senator Ameen, I don't want to cast aspersions on individual officers or anything like that. But there's parts of the system that is broken, and I think we have to accept that. Yeah? And that having provisions in place also, I also asked about if someone is under-invoicing an accident? I ask sometimes the dumb questions because I like to be the dumb person in the room. Under-invoicing, from where I said it's not an accident. Under-invoicing doesn't happen accidentally. People are deliberately trying to avoid the monies that they're supposed to be paying to the government of Trinidad and Tobago. So that if there's requirements for them to pay the difference and to do whatever is required under the Act, I support that. It put the pressure on them. Put the pressure on them. Because we're not dealing with babies here. We're dealing with experienced businessmen. Under-invoicing cannot be by accident. There may be one accident out of 100, but I suspect over 100 cases of under-invoicing, the majority of cases of under-invoicing are deliberate because they're trying to evade the tax net. And that's not something we should encourage. Because we're too soft on some of these people. Too soft. Madam President, yes, I have one other item that I want to flag. Yeah, and that's to do with the Exchange Control Act, Clause 6. So I agree. I listened to Senator Mahabir. The whole issue of the 5,000 use and the 20,000 TT, I believe some harmonization is required. But I have a question for the Honorable Attorney General, because I looked for the definition of person. What happens in other countries, and I went to the US Customs and Border Protection, the UK Customs and Border Protection website. the ability to bring in the US is 10,000, but it's per family. In the UK, it's 10,000 euros, but it's per family. So while they say, and it says cash, but they define cash as cash and all the other things that the bearable instruments. In the same thing in the US, it's cash, but cash is defined as cash, actual bills, and all the other instruments that can be converted into cash. But the issue is that it is per family. What you don't want is that 4 adults in a family turn up at the airport and say, well, each of us has 10,000 or 5,000, whatever. In all the other jurisdictions I check, Australia, New Zealand, Canada, everywhere I check, whatever the limit is, the limit applies for family. Once the family is flying together as a group, flying together, it's not 10,000 per person. So unless, of course, I'll be guided by the Honorable Attorney General, if in the act here, or the bill here, bill person has a definition to include family, that's fine. But I believe we need to qualify it, because that would be a gap. That would be a gap in the way in which the current bill is worded. Yeah, because I think that our citizens of Trinidad and Tobago tend to be very creative people. Just look at our wonderful carnival. People are very creative. They're very creative for good things, and then sometimes they're very creative for not so good things. And I think that people who are the same way, I am not an attorney, I'm not legally trained, I can look at this and find gaps. And I think people have found gaps in some of these things. So those are a couple of the things that I think need to be addressed, because perhaps I travel often, and when I travel with family, I'm very clear in terms of what it's per family. And even in the way in which we structure our immigration form, if you go to other places, it's one form per family. But we come to Trinidad, you return to Trinidad as one form per person, whether it's an infant or not. So, I mean, it has to be that, and you have to list on the back, but you still have to do one for each person. That's tedious. So those are things that we could think about. If we really want to fix the system, let's fix all parts of the system. Fix all of the bits and pieces. Why have somebody with 4 or 5 family members fill out 4 or 5 forms? They can fill out one form and say this is the declaration for the whole family. It's cleaner. And that's it. But that's only me, Madam President, because I believe that Trinidad and Tobago is a place where we have tremendous opportunity, but we have tremendous mischief. We have tremendous mischief. Because, for want of a better phrase, I think, Madam President, there's a lot of people who are very good, many of them advocates, at finding loopholes in the existing legal framework. And that's their job. As the Honorable Minister of Energy would hear me say, I would say that, listen, the oil companies who are here and they're doing what they do, they've been able to work the system, and they're trying to seek the best interest of their shareholder. All that needs to be happening on our end is we should be trying to seek the best interest of our shareholders. And that's all. And it's not anything to get angry about, it's about holding our position. As I begin to wind up, Madam President, I must exhort all to my continued consternation at the apparent lack of action on prosecution and matters for which there seems to be a world of evidence pointing towards wrongdoing. We are passing the legislation, but the prosecutions from previous things are not obvious. When I looked at the FIU Act, the FIU report of 2017, and you see the number of persons charged for money laundering, I think it's a total of 9. You know, the previous year was a total of 7 persons charged. Exactly where those things are, I don't know. Several for money laundering, but here's the big number. Of the persons charged for money laundering for the period October 2016 to September 2017, the value is 25,000 US. So, okay, something is happening, but not enough is happening. In a situation where, as the Attorney General, all of us have the same FIU report, $22 billion, people try to get that out of the system. Where does $22 billion reside in Trinidad and Tobago that's doing nothing? That you want to get it out of Trinidad and Tobago or do other things with it? I perhaps, because I'm a regular, normal person, I don't get it. So I don't get it. My colleague across the table here was just saying, Smolly, I know you're a man, you like to earn well. I say, but I don't earn that well. and it's perhaps just as well that I don't earn that well. Because I believe that in order for us to fix the problems in this country, we have to target all of the various areas. And we have to apply, we have to first institute penalties that are harsh and seem to be harsh, because here's what, people are doing things in this country with impunity. They're doing it with impunity. And I believe that the only way to fix this is to try to keep targeting these various individuals and organizations, entities, and try to plug the gaps in the various pieces of legislation that we're trying to do today. Strengthening the pieces of legislation. That's what we're trying to do today. Look at places where people have found ways to attack the system. Madam President, my other major concern has to do with the degradation of my quality of life as a citizen in this country. And it's a real concern, because the current state of our country is degrading my ability to enjoy Trinidad and Tobago. And that's my own personal experience. Other people may have other experiences. My ability to enjoy Trinidad and Tobago has been degraded and continues to be degraded. And a lot of it has to do in which people who are committing crimes, and there's levels of crime. There's the guys who are running around doing all sorts of hold-ups and whatever. But there's the other guys who are stealing from the state. They're systematically stealing from the state. I sit in another place in this building, Madam President, and I see the information there, and my mind is like, how can people do this systematically over a period of time, and then they get away? They just walk away. So, Madam President, it should not be lost on anyone that there's a link between unfettered criminal activity of all types and a reduction in our living standards. We have to understand that the fact that living standards in Trinidad and Tobago are going in a negative direction is because we are not able to get at the people who are doing, and it applies to white-collar crime, blue-collar crime, all types of crime, because they all have different but similar effects. They affect and degrade the quality of life of the citizens of our country. Because we mustn't forget that white-collar criminals destabilize our economic system and systematically reduce the ability of the government to ensure that resources are evenly distributed as possible. That's what they do. The economic criminals reduce the ability of the government to do its job. The economic criminals in this country, the banks, starting with them, going down the line. The economic criminals. Yeah? Forgive me, Madam President, I withdraw. Madam President, forgive me. I became a bit impassioned, and I seek your kind understanding. Madam President, as I start to wind up, the current state of affairs is that those who have are having more, and the average citizen is having less. And I believe that the package of legislation here, I don't believe that it's the cleanest or it's the best package that I've ever seen, but I believe that it's a step in the direction that takes us into a place where we could start to put some controls on what's going on. And that's what I'm here for. If nothing else, my record here was so that I am supportive of things. We could try to find a way to put some controls on the way in which the country is getting away from us, and we can pull it back. Yeah? I want us to be able to pull it back. And Madam President, given that you've been very pleasant with me and allowed me to speak, I want to thank you for the opportunity to be able to join in this debate and to share a few words and thoughts and concerns. And I want to say this, Madam President. Every day I make peace with the Father. I get up in the morning and I give thanks for everything, Madam President. I'm a simple guy. I believe that life is nothing is granted to anyone. Tomorrow is granted to no man. So I come and I try to make the best of every day. So, Madam President, I've tried to give up my best, and I want to thank you for the opportunity to join in this debate today. Thank you very much.
Am I on? Yes. Thank you, Madam President, for allowing me to participate in this debate this evening at just after 6. I must say that any bill that seeks to enhance our ability to get a grip on the criminal element, either blue collar, white collar, or any color, is something that is likely to have my full support. And we have been consistent with these type of bills, both in opposition and in government. I remember sitting on that side and lending my support to many, many bills brought by the then government at the time. And some of it is touched on or further enhanced with this bill today. Now, after listening to Senator Ameen, Senator Mahabir, and lastly, Senator Small, I think I should probably sit back down and let's all congratulate the Attorney General and go home by 7. Because actually they provided very good support for the bill. And despite some caveats and so on, this seems to be a pretty well-crafted and well-thought-out bill, omnibus bill, as Senator Small put it. And so I will just briefly, in terms of lending my support, point out a few issues that I think could be useful in terms of our understanding of the problem that we are facing, the issues that we're dealing with. I mean, I've been involved in issues of money laundering and financial services at the academic level for quite a long time. And my first presentation on money laundering and countering terrorist financing probably goes back more than 10 years. And I've also been involved at the regional level in terms of the CARI Forum EU conferences on financial services, because this is a very big issue for not just Trinidad and Tobago, for the Caribbean, because Caribbean islands are always accused of either harboring tax criminals or harboring money launderers. Right? And many of our smaller neighbors in the region suffer the consequences more so than us when they are threatened to be blacklisted and graylisted and all these things. And many of them, I've learned from attending the forums, that begin to feel that they're being victimized by the bigger powers, the people in control of the FATFs and so, of the world. And in many respects, they feel powerless to push back. And to a large extent, that is true. Our ability to push back against recommendations of these international entities is very, very restricted. So we must comply to a large extent. But there's a good side to it. It's not all negative in that we're not just complying for compliance sake. We're complying because of what some of the previous speakers mentioned in terms of the scourge of international terrorism and money laundering and associated criminal activity. Now, money laundering and so on, which this bill partially seeks to address, is a serious crime, as Senator Small was alluding to. In our context here in Trinidad and Tobago, maybe the $22 billion that is being referenced is a symbol of not just the fact that Trinidad and Tobago may be a conduit country, like most of the Caribbean. What I mean by that is Cayman Islands, Bahamas, and all the other offshore financial centers are usually referred to as conduit countries, where money passes through but it doesn't stay, right, by the international entities. They refer to them as conduits. As opposed to havens, where the money actually ends up. And in the case of Trinidad and Tobago, there's some indication that we are both. We are a conduit for international money, but we are also a haven for the money, in the sense that our financial system is much more developed than some of the smaller territories. Our banks are slightly bigger, and there's stuff you could buy in Trinidad and Tobago that may not be available or maybe too difficult to access in other parts of the region. Now, the problem with money laundering is that one of the economic problems, Senator Small was alluding to it, but I'll put a little more flesh on it, is that it distorts prices. One of the reasons we care about money laundering from an economic perspective is that it distorts prices. And I'll just give two examples as to why we need to address this issue even from a purely economic point of view. One is the problem in our real estate market, We know from past experiences here and internationally that one of the attractive markets for money launderers and drug dealers and so on is real estate. And what happens in small territories especially is that when these people with their ill-gotten gains try to clean their money, launder it, they push up the prices of properties and they price poor people out of the market. Okay? So that is one of the significant negative economic consequences of money laundering. And we have seen that, some evidence of that, because I've had studies done under my watch on money laundering and the impact on the economy as late as 2016, one of my MSc students. And then going further back, I also did studies on the housing market and housing prices in terms of trying to explain why the prices of certain houses were so high, even in areas where the average income doesn't seem to be able to support house prices of those, of that value, right? Because there are certain parts of the country where if you go to the official statistics, if you can get them, and average income is $7,000, $8,000, and you have the average price of a house being $2 and $3 million. How could they afford that? And that is something that has stuck out over the years. Okay? If you look, and I wouldn't call the regions because I don't want to stigmatize anyone. But money laundering distorts prices, right? And as I said, real estate is just one example. The other important price that money laundering distorts is the one that is very important to all of us, the foreign exchange, the price of our dollar. And as many of you know, in fact, all of you are probably familiar with the problems that are going on right now, where you are hearing people exchanging the TT dollar for as much as, well, 7 to 1, 8 to 1, right? And I've heard as many as 10 to 1. Yeah, call it murder, right? And so we know that, and where that is coming from, the proliferation of certain entities, certain businesses over the recent years. I'm sure many of us know. If you read the mutual evaluation reports from FATF or CFATF, it's all there. They make reference to all these things. The proliferation of what they call listed businesses. In terms of casinos, certain restaurants, and so on. Well, and the casinos doubles as, the restaurant doubles as casino as well now, and bars and so on. So there's need to get a grip on this because many of these people take no account of the impact of that they're having on the local economy because they want to get their money out. And many of them are from a foreign origin, from other countries that are operating in Trinidad and Tobago. So it means nothing to them, what happens here. So if they get a lot of money, and we have to consider casino money laundering, because as far as I know, it's still illegal, right? A casino is still an illegal operation in Trinidad and Tobago. So proceedings from it has to be illegal, right? And when those people offer the average person $7 and $8, $9, $10 for a US dollar, it puts pressure on all of us because our exchange comes under pressure. And we in the government get the feedback, well, every minute that, well, you're going to devalue, right? You're going to depreciate the dollar. And I get it all the time because people think somehow I know. So they come up and ask me all the time, you know. And they want to get the inside information. And they keep asking me, some businessmen where anywhere I go, they ask me, well, you know, you must know, you know, the minister is going to devalue tomorrow when he talks in Parliament, right? And I said, well, what do you want? If you devalue or let the currency depreciate, whichever terminology you prefer, what is going to happen? I said, I know what you want. You want it to go to 10 to 1 or 12. And I say you will make a few millions because you're going to bring back some US you took out before.
Fixed deposits in private US dollars.
Yes. So you're going to make a few millions, and because you're going to bring it back at a higher exchange rate, right? You bought it at probably 6, took it from the central bank. When the central bank put money into the system, you were fortunate enough to get in the queue, and you got it at the central bank rate. Okay? And then if it goes to 10 to 1, you bring it back in, you make $4 just on each US dollar. I mean, I've been studying this for quite a long time, so I know it works. And I told one businessman in particular, I say, so okay, so you're going to bring back a few million US, convert that, make 3 or 4 million TT dollars. And what are you going to do with it after? Are you going to migrate? Your business is here, you live here. What's that all about? Don't put the country in jeopardy by trying to force an issue when it is not necessary. We have known for 20-something years we lived with a relatively stable exchange rate at around 625, 630. So we know it's possible. And we know that speculation is really what is driving the demand for this devaluation or depreciation on the part of many in the business community and others. So Trinidad and Tobago, as I was saying, is a potential conduit in terms of people passing through money, especially from the drug trade, and also transitory individuals who are here short-term, looking to make a quick buck, get converted to US, and go on their merry way. So because of our market and the size of the financial system, we double as a conduit and a haven country. Now, with respect to the mutual evaluation report, which is consistent with what is in the bill, especially as it refers to the FIU, we have shown significant improvement over the years. When I started looking at these things, it was kind of embarrassing to look at a mutual evaluation report, and out of 40 recommendations, the country used to be compliant in 2 and 3. And you used to just see a big set of NCs going down the list, non-compliant, non-compliant. And over the years, I'm talking over an extended period, we have made significant progress. And I think this bill today is another step in that direction. That's why I think it should be fully supported by all present here. Some areas in which we still need to take a close look at, as flagged in the mutual evaluation reports, the issues of credit unions, in terms of the ability of credit unions to really monitor and evaluate and keep track of their customers and implement any kind of risk assessment in terms of their exposure to money laundering and especially money laundering in particular with the credit unions. The other entity that they flag that we have a lot of work still to do is the nonprofit organizations. And this one is particularly relevant in the sense from the point of view of financing of terrorism, because as some of you are quite aware, in the international arena, a lot of financing of terrorism goes through nonprofit organizations. And we have some work to do in that area, because a lot of if you look at the recommendations, I have them here, wouldn't take time to read them precisely, but they talked about the lack of regulation, a lot of requirements that these nonprofit organizations have in terms of being able to identify potential money that it may end up in financing terrorism. So we have some work to do in that, and one of the FATF recommendations is based on that. Well, of course, they have quite a bit. In terms of the international cooperation, they, I think, extensively point out our weaknesses. in terms of sharing of information, and in fact our ability to share information is what this bill is trying to help correct in some way. We still have some ways to go. As I said, it is a step in the right direction. And one of the things that several senators have raised, starting with Senator Marby, about the 20,000 TT and 5,000 US. I know the Attorney General is quite good at defending himself, so I wouldn't say much on it, but it was a question of Senator Marby mentioning purchasing power parity, right? Really, it's a step further. He was really referring to the law of one price, so that if something is $2 US and the exchange rate is 6, then it's itself for $12 in Trinidad and Tobago. That's absolute purchasing power parity. That's the Big Mac index that he referred to. But I understand from the Attorney General it's a question of harmonization with other laws and that are being under consideration and will be dealt with at a later stage. So preference is given to this formulation only for the purposes of this bill today. But in the complete package, it will be explained, right? So I wouldn't detain the House any further. As I said, based on the last 3 speakers, both on opposition and independent, I think it's a very positive bill. It's a step in terms of our ability to deal with some of these issues that I described. And we, once again, congratulate the Attorney General on doing some excellent work here. I thank you, Madam President.
Thank you very much, Madam President, and I thank you for the opportunity for allowing me to join this debate on this Miscellaneous Provisions Bill 2017. And Madam President, this bill seeks to amend 5 pieces of primary legislation, that is the Mutual Assistance in Criminal Matters Act, the Proceeds of Crime Act, the Financial Intelligence Unit of Trinidad and Tobago Act, the Customs Act, the Exchange Control Act, and one order, which is the Exchange Control Import and Export Order 1993, made under the provisions of the Exchange Control Act. Now, Madam President, this omnibus bill touches and concerns the heart of the issues of money laundering and terrorist financing. And I go on record to say that the United National Congress, this great party which I'm a member of, we stand strongly for the fight against crime, and in this case, the fight against money laundering and terrorist financing. But the ramifications of this bill is that the rights and privileges of our citizens are being interfered with. And we on this side will defend the rights of those citizens. In this Parliament, we will continue to ensure that the bills that this government brings do not unnecessarily trample on the rights and privileges of our citizens, and that proper legislation is brought to this Parliament. And if proper legislation is brought, we would support it. Madam President, recently Trinidad and Tobago has been brought on the international stage, and not for the greatest show on earth, but what could have been the greatest disruption of the greatest show on earth. Trinidad and Tobago has now become viewed under a microscope when we conduct our business, as we have been named the country with the highest per capita rate of ISIS recruitment in the Western Hemisphere by the U.S. Department of State's Country Reports on Terrorism 2016. Madam President, terrorist organizations, their survival are dependent on the funding that they receive, and the money must be coming from somewhere. So when we look at this bill, it looks as though from a first glance that much is being done. But on a closer examination, this bill is just the tip of the iceberg. When you look at the 4th report of the Mutual Evaluation Report of Trinidad and Tobago on anti-money laundering and counter-terrorist financing measures, June 2016, it outlines 40 FATF recommendations. And under each recommendation, there are further recommendations, which I would call sub-recommendations. So why it is that we are only dealing with the recommendation that deals with mutual assistance? There are 39 other recommendations that we could have dealt with. So I'm asking why it is that this bill is being brought in a piecemeal manner. Why don't we sit down together and discuss all of those recommendations and the sub-recommendations that were made by the CFATF committee? And if you are serious about the fight against terrorist financing and money laundering, we should sit down with all the stakeholders, the business community, the judiciary, the Criminal Bar Association, the Law Association, and the public at large. Madam President, let me go into the nuts and bolts of this bill. From the same report, the fourth mutual evaluation report, at page 112, paragraph 410, under the rubric Recommendations on International Cooperation, it was recommended that the Mutual Assistance in Criminal Matters Act need to be amended to provide as follows. And there were 4 recommendations. 1, for clear and efficient processes for the rapid provision of assistance where a request is made. Remove the restriction on provision of assistance in the case of certain tax offenses. Remove the discretion from the central authority for refusal of assistance. And lastly, expand the basis on which confiscation orders can be made. Now, of these 4 recommendations, the Attorney General brought 1, and that is the removal of the restriction on the provision of assistance in the case of certain tax offenses. Why haven't we considered the other 3? The clear and efficient processes for rapid provision of assistance where a request is made. That is a practical recommendation. Also, we operate in such a reactive manner that there's nothing proactive being done by this government. And I say that when we look at the amendment that is currently before us, I would read section 22(2) subsection K. It says that such a request shall be refused if, in the opinion of the central authority, the request relates to a criminal offense under the tax laws of a Commonwealth country, save that the assistance may be granted if the offense is committed by way of an intentionally incorrect statement, whether oral or written, or by way of an intentional failure to declare income derived from any other offense covered by the Inter-American Convention on Mutual Assistance in Criminal Matters. Now, Madam President, under the current construct, these are exceptions where assistance can be granted. So it is not that we have currently section 22 subsection 2K operating that the central authority can just blanketly say, no, we can't lend the assistance. There are 2 exceptions. The first being that if the offense is committed by way of an intentionally incorrect statement, we can in fact grant that assistance. Or if there is an intentional failure on the person to declare income. And these 2 matters, these 2 exceptions, go directly towards the issue of tax evasion. And the offense of tax evasion, it's a predicate offense to that of money laundering. So therefore, the current construct, as I said, does not give the central authority the power to mandatorily refuse to grant the assistance. They can currently do so for money laundering offenses. Nothing prevents assisting a foreign state that requests information for money laundering. Now, Madam President, we must also look at the FIU's operation within the ambit of this legislation. They are the body responsible for the collection of financial intelligence and information and analysis, dissemination and exchange of such financial intelligence and information among law enforcement agencies. When we look at section 8, subsection F of the FIU Act, it empowers the FIU to give financial information relating to money laundering and terrorist financing to foreign entities. So the FIU may, in fact, disseminate these financial intelligence and information to local and foreign authorities and affiliates within the Intelligence Committee. So now we have an amendment where the FIU now can do so on its own motion. So therefore, Trinidad and Tobago, that we have the capacity in order to lend the assistance to those foreign states. When we look at Section 30 of the Anti-Terrorism Act, it also empowers the Attorney General under that act to share information with regards to terrorist financing to foreign entities and states. Now, Madam President, one issue that arises here is something called dual criminality. And the removal of Section 22(2)K is not the end-all of the matter. So if the bill is passed in this House today and we remove the section, when a state makes a request to Trinidad and Tobago for any tax information matter, the central authority does not just comply with that request and grants the information. What happens is that Section 22, subsection 3 of the Mutual Assistance Act now is engaged, where the central authority does have the power to determine if the offense that they require assistance on is a similar offense in Trinidad and Tobago. So therefore, what criminal conduct they're asking for information on must be an offense in the foreign state, and it must also be an offense in the domestic state, which is Trinidad and Tobago, which is what we will usually term as an extraditable offense. So therefore, the central authority, even if we remove this section, does have a discretion to deny lending assistance on any request to a foreign state. And when we look at the fourth report of the mutual evaluation at page 164, paragraph 747, it states that the MACMA, which is the Mutual Assistance in Criminal Matters Act, provides a wide range of powers for Trinidad and Tobago to provide MLA, which is mutual legal assistance. The issues of dual criminality and certain tax offenses being subject to refusal can hinder the process of the MLA. However, there's a wide discretion given to the central authority that can mitigate these deficiencies. So then I ask, why are we removing Section 22(2)K if the central authority does have that discretion?
Yeah, good.
Now, when information is being traded between states, the issues of privacy and confidentiality arise. And when we look closely at the Income Tax Act, Section 4 of that act, it provides, and I quote Section 4, subsection 1, every person having an official duty or being employed in the administration of this act shall regard and deal with all documents, information, returns, assessment list, and copies of such list relating to the income or items of the income of any person as secret and confidential. Therefore, this section deals with the manner in which citizens' information is to be dealt with. It must be done in a secret and confidential manner. That is the operations of the Board of Inland Revenue. They are not subject to the direction of any minister or official of government. And in an article dated Tuesday, the 6th June 2017 of the Trinidad Guardian, the Attorney General, when given an address to the Global Forensic Institute on the Caribbean Fraud Conference 2017, said this, and I quote from the article, that the secrecy provision in the Income Tax Act has to be opened up to allow for certain prescribed entities to access information for law enforcement purposes and to ensure somebody is guarding the guards. He said the proposal, which is the need to open up the Income Tax Act, requires a special majority. And there's a miscellaneous bill before Parliament for prosecution of tax evasion matters in a reciprocal arrangement. So I asked the Attorney General, having made that announcement in June 2017, has the position now changed that we do not need to create an exception to Section 4 of the Income Tax Act? Why was an exception created under the FATCA Act? Section 8 of the FATCA Act created an exception to Section 4 of the Income Tax Act where information can be now distributed towards the United States government, the IRS, sorry. So I would argue that the amendment if it's passed in its current form, would be deficient in that there would be difficulties in implementation, as the Board of Inland Revenue now can say, well, look, Section 4 operates. We cannot give you that information. Now, we must also look at other pieces of legislation that this touches on concern. Look at the Data Protection Act under Section 6 of that Act. We have general privacy principles. What about Section 55 of the Financial Institution Act? Oh, and I must say that these three legislation exceptions were created to them under the FATCA legislation, Section 8 of that legislation. So these are questions that the Attorney General, I hope, would address in his winding up. So I would say that the amendment is not enough if the government wants to get serious in the fight against money laundering and terrorist financing in the international arena. So is it that we are hurriedly pushing through this amendment so that we can just be deemed to be compliant when the mechanics of the entire process is defective? This cannot be. Now, Madam President, there must be a distinction made between mutual assistance and that of extradition. And the reason I raise this point is because the debate on this bill on another place, certain statements were made regarding extradition, and I think that I would like to address it. I hope that you give me the opportunity to do so. And I quote from the Hansard, dated the 17th of November 2017. And it says, the Attorney General says that the Mutual Assistance in Criminal Matters Act, Chapter 1124, is the act which says that Trinidad and Tobago will...
Madam President, I must rise regrettably on relevance, because this is not a debate in the House, nor is it raised here. And therefore the relevance to this debate, because if one is to be honest, that answer that is now about to be read was my own explanation as to why the other members got it wrong in confusing extradition. So it's untidy, and I ask for your guidance on that.
Senator Hossain, continue.
Madam President, as I was quoting, it says, as it goes, it says how Trinidad and Tobago will treat with mutual legal assistance requests. People may know it is an extradition request. Best as a, let me repeat that. Trinidad and Tobago will treat with mutual legal assistance requests. People may know it as an extradition request, best as a feature that is popular in Trinidad and Tobago. How other jurisdictions will treat with those requests from Trinidad and Tobago. How the Commonwealth jurisdictions will be treated, and how the non-Commonwealth jurisdictions will be treated. In Section 22 of the Act, Section 22(2)K, there's a specific provision which says that a request shall be refused where it relates to a criminal offense under the tax law, and it goes on. And then the Attorney General goes on in the same debate to say that the removal of this prescription, which allows the Attorney General to refuse matters for extradition which are related to tax laws. Then in an article dated June 2016, commenting on this bill, he said that we will extradite persons who are deemed to be wanted in a foreign jurisdiction for tax evasion. Currently, the law as it stands is that the government could say no if an extradition request is made for tax evasion purposes. He said, adding that the discretion is currently being reviewed. So basically, the Attorney General is saying that we cannot extradite anyone where it involves matters of tax offenses. Madam President, I would like to say that is, in fact, not the position. The position is that any state that requests an extradition for a person with regard to tax evasion can, in fact, be extradited. Section 5 of the Extradition Act states that the offense must be an extraditable offense. And as I said earlier, the offense must be an offense in the foreign state, and it must be an offense in the domestic state, and there must be a treaty operating between the both countries. So that is the requirements for the extradition of a person. Now, when we are looking at the request under the Mutual Assistance Act, Madam President, it's totally different. Because in that it says is that all that has to occur is that one foreign state just makes a request and we will determine whether or not we lend the assistance. Under the Extradition Act, the request has to satisfy certain formalities. And some of those formalities are that it must be an extraditable offense. They must attach a warrant. Yes, ma'am.
We're not dealing, though, with the Extradition Act. So while I have allowed you to deal with the Hansard and to make you to understand what you're saying, don't go into the Extradition Act, okay? Because it's not relevant, really, to this debate.
Thank you for your guidance, Madam President. And I would just like to quote from the Mutual Assistance Act, and to show that there's a difference. And it says that Section 6 of the Act says, if you would just allow me to just quote the section, this is the Mutual Assistance Act. Nothing in this Act authorizes the extradition or the arrest or detention of any person for the purpose of an extradition. And I end there with respect to this point, Madam President. So, Madam President, we must look at the enforcement of the legislation now. Because under the Mutual Evaluations Report, they have noted that there's need for clear and efficient processes for the rapid provision of assistance where a request is made. And they had alluded that we need to amend the legislation to provide for rapid assistance, because we can't be asking for, a foreign state can't be asking us for information and we let it sit on the central authority's desk for 3, 4, 5 years. That person would be long gone and evade and probably go to several other jurisdictions and commit similar type crimes. So that is one of the recommendations that the Attorney General should have brought to this Parliament. And also there are other amendments, such as the removal of the dual criminality, because there are other countries that seem to be going that way, such as South Africa, where they have removed that requirement for dual criminality. Now, these are issues, again, and gaps that we are seeing in the legislation. So this is an even more stronger case for the fact that the Attorney General should have referred this matter to a Joint Select Committee for us to consider and deliberate on it. Now, Madam President, I want to go on to the other act that this bill seeks to amend, and that is the Proceeds of Crime Act. And the current law as it stands is that the offense of money laundering is actually a strictly indictable offense. And the act and the amendment to this act now seeks to make it a hybrid offense. So the sanctions for the summary offense and the indictable offense has changed. So they have added the summary offense to be, a person is to be fined $25 million and to 5 years imprisonment on summary conviction, and a fine of $50 million and to 30 years imprisonment on indictment. Now, one of the reasons the Attorney General stated for the inclusion of money laundering to be regarded as a summary offense is due to the backlog at the magistracy with dealing with preliminary inquiries, because as we all know, every indictable offense, they must go through that preliminary inquiry, and sometimes it gets delayed. Now, there are certain ways that this could have been circumvented, where paper committals are now being used to try to fast-track the procedure. Now, the Attorney General also alluded to the use of the criminal procedure rules. Now, I think the Attorney General needs to do an evaluation of the courts and find out how many magistrates and judges are actually using those rules. Now, I am saying that this amendment actually does not solve the problem of the backlog, because all these hybrid offenses are laid as indictable offenses. And the only way that these offenses can actually be tried summarily is by the consent of the person being tried. And this is stated clearly in the Summary Courts Act. So now a reasonable person who is charged under the money laundering offense, they appear before the magistrate, and the prosecution recommends that they go summarily with this charge. Do you think that person is going to say, well, yes, I want my matter to be heard here in the magistrate court, and I will be fined $25 million and 15 years imprisonment? No. They know that the system is delayed, so obviously they will choose to remain in the indictable procedure so that they can get several years for that preliminary inquiry to be up, and then they have the option to now be tried before a judge and a jury where they probably think that they might see more justice. So is it that this provision is actually really going to help the backlog? Because we are looking at these persons still retain the right to determine whether or not they want to be tried indictably or they want to be tried summarily. Now, this raises even more issues because in Trinidad and Tobago, under the Mutual Evaluations report, it says that the jurisdiction has recorded 3 cases of money laundering that has resulted in charges being brought against 5 individuals. All these cases are currently pending. The information is that there are no arrests for standalone money laundering offenses. All of these have been coming out of predicate offenses. There's a lack of priority given to the investigation for the offenses in money laundering. And none of the cases of which persons have been charged with money laundering have been adjudicated by the court. And this creates a difficulty determining whether these cases have been properly investigated. And in the absence of convictions for money laundering, despite the passage of legislation for 14 years, it is not possible to say conclusively that matters are being properly investigated. The absence of convictions of the offense means that no sanctions have been applied by the court, and the offense of money laundering is not given priority in the court system. So I ask, Madam President, that since there have been no convictions, how can we be sure that these persons, persons who are convicted now, their convictions are safe? And then, since there are no convictions, you now come and increase the fine from 25 million to 50 million. You double it. 15 years imprisonment to 30 years imprisonment without a single conviction, Madam President. And we must also look at the environment in which matters operate in this court. The magistrate court is already burdened. They lack resources, CAT reporters, recording system. Some magistrate courts don't even have a building. Imagine the San Fernando Magistrate Court. I believe that court falls under the constituency of the Attorney General. Yeah. And that building has become so inhabitable that they are forced to be under a shift system. They can only sit for a limited period of the day. And we want to now convict persons to pay $25 million and then, or 15 years imprisonment when we have a court system that doesn't even work, Madam President. I want to suggest to the Attorney General that we look at models from all over the world. Because we on this side, we're not about just creating problems, but we're about offering solutions. And one of the solutions I think that we should offer is one of specialized anti-corruption courts. Now, there are certain jurisdictions around the world that set up these courts because of the complexity with regards to the prosecution, the investigation, and the determination of tax offenses matters. And there have been, in 2015, 17 jurisdictions that have set up these courts. They're Afghanistan, Bangladesh, Botswana, Bulgaria, Burundi, Cameroon, Croatia, Indonesia, Kenya, Malaysia, Nepal, Pakistan, Palestine, the Philippines, Senegal, Slovakia, and Uganda. And 3 other countries, Mexico, Tanzania, and Thailand. So the world is moving progressively towards being serious about prosecuting these types of crimes. And I don't want the government to come and say that, well, we have no money to set up these courts, because there's evidence where there have been international donors who have been heavily involved in providing training, financial support, and other assistance to these institutions. And these are independent donors, such as USAID, the United States Agency for International Development, the UNODC, the United Nations Office on Drugs and Crime, and the UNDP, which is the United Nations Development Program. All of these organizations have helped countries set up courts in place in order to prosecute these types of crime. And I'm saying that we need to have a similar system because magistrates in Trinidad and Tobago, they may not be trained in order to determine these crimes unless they have undergone serious training, because these are very complex fiscal matters, Madam President. And we must also, part of the criminal justice system is the investigation arm of it. And we must look at the role that the SSA has in this. And I have a timeline of events. By Act 4 of 2016, the remit of the SSA was expanded to give it powers to deal with matters of money laundering and terrorist financing. And then there was a restructuring exercise that took place around November 2017. And now the SSA is exempt from the Freedom of Information Act. So, Madam President, we now have this body that is collecting information regarding money laundering and banking information, and we cannot ask any questions regarding the SSA.
Senator, now you are going into the realm of irrelevance, because this debate has nothing to do with the SSA and freedom of information. So I'd ask you to get back on point, please.
Yes, please, Madam President. But, Madam President, a lot has been said in this debate about follow the money. And I'm going to say that this government must follow the money in the fake oil scandal. They must follow the money in the Ferrygate. They must follow the money for the suspicious transactions of government ministers. And they must follow the money for the award of government funds to their relatives. We must follow the money, Madam President. And we must follow the money for the $2 million found in the plywood. They must all face the full brunt of the law. They must face the $25 million and the 15 years imprisonment, or the $50 million. And this brings me to another point, Madam President. How much time I have again?
So you have 11 more minutes.
Yes. And this is the last act that I will be dealing with. This is the Financial Intelligence Unit Act. And I want to go straight to Clause 4E of the bill. And I consider this to be a very dangerous amendment, please, Madam President, because it goes to the heart of a citizen's right to silence and a citizen's right to be protected against self-incrimination. Now, the clause actually proposes to give a police officer, no rank specified, the power to apply for a warrant in order to provide information to him. What is interesting is that ordinarily, if a police officer stops you on the road, you have a right to say, no, I'm not giving you any information. That is your right. You have a right to remain silent. Even if you are detained or you are charged by a police officer, you still have that right to remain silent. And that is found in the judge's rules in which the police officer operates with. That is the caution that they administer to a suspect or someone that they have charged. Now, in the case of the FIU, they may require any person. You're not charged yet, you know. You're not detained. They come and they say they need you to provide documents. They need you to provide information. They need you to provide explanation of any information. And a warrant can be obtained by them to do this. And if you obstruct their duty, your penalty is $10,000, you know, or 12 months imprisonment. So what about a person who chooses to exercise his right to remain silent? Is that obstructing the police from executing that warrant? What about if I say that I am not going to give you any information because my lawyer is not present? Is that obstructing the police in executing their warrant? The mere fact that there's one section of the FIU Act that says that that it protects you against the right to self-incrimination is not enough. Because when would a person know that he's not incriminating himself?
Exactly.
Because these fiscal matters are very complex, and I keep saying this because of how regulated that the industry is. And the information that they give, they may not actually be aware, or even the police officer may not be aware that that person is incriminating himself. And these are rights that have been pronounced by the court, the right of silence and the right against self-incrimination. In the case of Vasquez and the Queen, 1994, WLR 130, it was said that the protection for fundamental rights and freedoms in the Constitution should be construed generously and extend to related rights and freedom so as to include the right to pre-trial silence and the privilege against self-incrimination. In Trinidad and Tobago, our Court of Appeal In Hayden Tony against PC Joseph Corrapps, Magisterial Appeal 68 of 2008, Justice of Appeal Barrow said, the right of silence and privilege against self-incrimination forms part of the due process provision set out in Section 4A and the right to the protection of the law set out in 4B. These are constitutional rights. And there's a similar provision to what is being proposed in the FIU Act that is in the Anti-Terrorism Act. And that is Section 24 of the Anti-Terrorism Act, where a person can get, where the police officer can make an application to get information out of the person. So there's a distinction now that between the FIU and the Anti-Terrorism Act. Under the Anti-Terrorism Act, these are the safeguards that they have included in that legislation for obtaining such I would say, instrument or device in order to extract information from persons. First, the officer must be a rank of inspector or above and or above. In this case, they have not indicated what rank the officer should be. Secondly, it's not a warrant that the Anti-Terrorism Act operates under. The police officer actually has to go before a high court judge in chambers and get an order, and that the application can only be made by consent of the Director of Public Prosecution. Now, in this case, the police officer can just go to the magistrate and get the warrant. The order must have conditions. For example, the examination should be done under oath, the time and place for the examination, and the documents that they require the person to produce. Also found in Section 24 is upholding the right to non-disclosure of information that is privileged. It also gives the judge the power to rule on objections to answers given or produced in the interview. And a person may retain, and it also includes that a person may retain and instruct an attorney at law at any stage of the proceedings under that section, and that the attorney at law so retained may attend and represent the person named in the order when he is being examined.
Hussein, you have 5 more minutes.
Thank you very much. So, Madam President, these are the safeguards that are given to a person under the Anti-Terrorism Act. Why it is that these exact safeguards were not placed in this FIU amendment, Madam President? So, we must take measures to ensure that we don't interfere or trample on persons' rights. This sets a dangerous precedent when a corporal can go to a magistrate and get a warrant and compel a person to give this information. And then if you don't, you're what? Liable to $10,000 and 12 months imprisonment? You can't do that. So, Madam President, in conclusion, my recommendation is that this bill should be properly brought before a joint select committee, because as it stands, there are several issues that need to be ventilated and ironed out. We must get the stakeholders involved. This bill has far-reaching consequences, and there are a lot more recommendations that were not included. So I ask the government to dialogue so that we can stop passing piecemeal legislation. I thank you, Madam President.
Senator Shrikissoon.
Thank you, Madam President, for allowing me to contribute to this debate at this time. The bill before us is a very comprehensive one that deals with a number of different acts. But before I begin my presentation, I would really like to commend the government and the Honorable Attorney General for piloting this bill, bringing this bill to the House. And as I communicated with the Attorney General a little bit earlier today, I was particularly happy with the way in which he presented and which he piloted the bill, because he presented it in a form that could have been easily understood and followed according to the way in which the bill was laid out. So I found it to be a strength of his presentation, and I commended him for this, because it really facilitated an understanding. So to the Attorney General and to the government by extension, hats off to you all with respect to that. But while on the notion of commendations, I also would like to say that I enjoyed Senator Hussein's presentation as well. And there's some degree of overlap with his and mine. Him having some concerns with some areas of the law before us, so the bill before us. But I would like to say at the outset, and to take a position where Senator Small left off, am I happy with where Trinidad and Tobago is at? And the answer is no. Am I happy with the direction in which we're going? And to me, on a daily basis, it's getting a little scarier. And as a result of that, I'm unhappy with the way that the direction which we're going. As a citizen, am I comfortable? Do I feel safe? Am I fearful? And the answer to those questions would be I am scared. And something has to be done. Something has to be done. And if it is that we leave everything unregulated, or we don't seek to address it in some way or fashion, if we do nothing, then nothing will happen, nothing will change. And therefore, if this bill would allow us some element of change, in that we can introduce into society some element of regulation, and it offers some element of hope, a glimmer of hope for citizens, then most certainly I will support the bill. Thank you. I don't know which bench you're on. but you're welcome. But thank you. And so I really would like to hope that this piece of legislation being presented here offers a ray of hope for Trinidad and Tobago. And if it does, I welcome it. So in an attempt not to be repetitive with respect to what has been said before, this bill that's brought before us today is entitled An Act to Amend the Mutual Assistance in Criminal Matters, the Proceeds of Crime Act, the Financial Intelligence Unit of Trinidad and Tobago Act, the Customs Act, and the Exchange Control Act. And they've all been listed and mentioned by all of the speakers before. But the point that I want to get at here with respect to these acts here is that all of these acts pertain to transactions which involves Trinidad and Tobago and other islands or countries around the world. So that the request for information or the amendments being sought here today most certainly involves a regulation of what's going on externally, or as Trinidad and Tobago connects and transacts externally to, with other agencies. And if it is that this is one way in which we can regulate activity in Trinidad and Tobago, then I welcome it. So to get to Clause 2 of the bill, Clause 2 of the bill seeks to remove a condition under which a central authority can refuse assistance if the request relates to a criminal offense under the tax laws of a Commonwealth country. The Attorney General explained why this was necessary to be removed. And I also heard an argument being put forward by Senator Hussein, of which I can't really make a judgment call on it because of their legal background. But what I would say is that I do recall around December 2017, the European Union blacklisted Trinidad and Tobago with respect to Trinidad and Tobago being identified as a tax haven. And one of the criteria that they would have used is that of information sharing and cooperation. So therefore, am I happy as a citizen with Trinidad and Tobago being blacklisted? And clearly the answer is no. Why? Because I don't want it for Trinidad and Tobago, and it also involves trading. It makes trading more difficult, because when your institutions that represent you belong to a country that has been blacklisted, obviously it will make trading harder. And specifically to the business community, it makes life harder. So do I want to belong to that? And the answer is no. And therefore, it has to be fixed. It has to be fixed. So with respect to the EU blacklisting Trinidad and Tobago, and if you followed up that report in January, the EU also offered an amended list where certain countries were removed from that list, but Trinidad and Tobago was not. So therefore, why was Trinidad and Tobago, or has Trinidad and Tobago maintained its position on that list? And it's because we didn't fix it. And so we need to fix it. So with respect to that, I'm saying if the removal of the clause allows for information sharing, then I welcome it, because it places Trinidad and Tobago in a more positive light. But more specifically, and it's a topic that I've raised in this House on multiple occasions, if we are to promote Trinidad and Tobago as a center or as an international financial center and attract investment, it cannot be that Trinidad and Tobago is on a blacklisted, or is on a list or blacklisted for financial transactions or not being able to cooperate with agencies and information sharing. It's a clash. It's two different directions. So it has to be fixed. So to the government, while you're attempting to fix it, in positioning Trinidad and Tobago and also in crafting your strategies, you need to be clear-cut that these obstacles along the way that will present itself as your charter course to Trinidad and Tobago should be fixed up front. and not in a reactive manner like this. So that's a concern that I would have. So, but I'm happy that it's being addressed. It's just I would have wished that we would have done it in a proactive style, or rather than being reported or presented in this way, and now we're going to fix it. But many presenters before me referred to the FATF report, or the Mutual Round Evaluation Report. And Senator Hussein read from a lot of it, or quoted a lot from it, and I too would have looked at it. So I'm just going to touch on it in an attempt not to repeat everything that he says. But with respect to Clause 2 of the bill, Recommendation 37, page 163 of the report, and it says, there appear to be no unreasonable and unduly restrictive conditions except where it relates to a criminal offense under the tax laws of a country. So the report was very specific that this was really an obstacle. And the report has identified that this area needs to be addressed. And it is in my view that the removal of this clause, as in Clause 2 of the bill, really addresses the concern raised, and therefore I accept the recommendation of the report as well as the action of the government to address this concern. Clause 3 of the bill seeks to amend the Proceeds of Crime Act. And again, the major amendment here is to now list money laundering as a hybrid offense that can now be probably tried summarily or indictably, if I'm correct. Again, if I go to that report, of that FATF report, it says here on page 6 of the executive summary, it says, money laundering investigation and prosecution. Law enforcement agencies in Trinidad and Tobago considered the risk associated with money laundering as being medium to high. The jurisdiction has recorded three cases of money laundering and have resulted in charges being brought against 5 individuals. Now, I can go on to read the rest, but Senator Hussein quoted extensively from this aspect. But just to highlight his main points, and the report, it says, no arrest for standalone money laundering. The investigation of money laundering is not properly prioritized by law enforcement agencies. There's been an absence of convictions. The absence of convictions has led to the courts not applying sanctions, and the offense of money laundering is not given priority within the court system. Here's the point. If it is that this level of activity concerning money laundering is going on in Trinidad and Tobago, and it has such a high incidence, so much so that it is recognized that even through the court system it's not being adequately addressed, then the question is, if the charge has now been classified as a hybrid offense, that the charge can now be laid indictably or summarily, would that really lead to the result that we want? And given the problems of the magistrate court, and even one person earlier said today, if you really understand the challenges of the magistrate court, you wouldn't even want to go there. So then would it really yield the result that we're looking for? And I'm questioning that. Now, the motive is good. And from the report, we're answering a call from the report to address an issue, but whether or not we're addressing the issue to bring about a desired result, or are we addressing the issue to bring about compliance? Now, why would I say this? If you look, and again, many speakers before me quoted from the FIU report, and even the Honorable Attorney General, and in that report, it says here, if we examine the number of suspicious transaction reports or suspicious activity reports, we realize that in 2016, or in 2011, we just had 303. But by 2016, it was 739, and in 2017, 877 suspicious activity reports. This had a cumulative value in 2017 of $22.2 billion. Then how is it, with such a high incidence of suspicious activity reports, we are unable to charge and convict? And I have a question with that. Because if it's 877, if we just take 300 working days in a year, that's on average 3 per day. So if we have an incidence occurring at 3 per day, how is it that our system that we have is unable to convict, to prosecute, convict, and apply sanctions? And is it that the magistrate court, that everyone is saying it's not the right modus operandi to prosecute given the backlog there? Will it help? And I don't really think that the answer is yes. And to quote from the FIU report again, if you look at corruption, including misbehavior in public office, carried a value of $132 million in 2017. So it's telling us that while we're saying that we need to fix Trinidad and Tobago, some of the actions of people or those like us who hold office are also not conforming. And we are helping, or we are putting Trinidad and Tobago in a bad position. We are contributors. So it's not just about the general public, but all of us, we need to evaluate it and look at it. So we need to address that. So I'm agreeing, or I'm saying here today, if the charges can now be laid summarily or indictably, would it bring about a desired result? And that's my question. Would it bring about the change? And I want to say that I don't believe it would. Then what's the corrective action? So we're at the same place, although the legislation would be passed. The report also says, the FATF report, the Mutual Round report says on page 10, further recommends that there is no law for facilitating as an ancillary offense to money laundering. So then the question is, as Senator Hussain says, yes, we're amending the law, but then if we're amending the law because of the report, why are some concerns of the report addressed and some aren't? And on my last point with respect to this area of the bill, clause 3, it says here, and I want to say this, if you look at the penalties assigned to anti-gang and terrorism, you will realize that with money laundering, it's laid, and the charge was laid in summarily 15 years and 25 million. With money laundering, indictably 30 years and 50 million. With financing terrorism, 25 years, but 5 million. And so I'm saying, I'm raising the question, or I'm raising the flag, how is it that we can introduce the possibility of a charge being laid summarily, having a penalty of 15 years and 25 million, but a terrorism or a charge with terror or financing terrorism has a 25-year jail term or term, but 5 million in penalty? It's saying to me that the law is not equitable, because the charges are related, but the penalties aren't. And so I'm asking, can we look at this to bring some bit of equity in the law? Clause 4 of the bill, Madam President, introduces or seeks to amend the FIU Act, the Financial Investigation Unit. And it says here that, and one of the amendments is saying that the FIU shall collect information as required for tactical analysis in order to generate activity patterns, trends, and typologies, investigative leads, and identify possible future behavior. And so today, if it is that we're introducing the use of statistical derivatives in terms of trends and typologies to indicate some elements of pattern of behavior that's occurring, then I'm endorsing it. I'm saying yes. Let's be able to use statistical data as well as technology to determine whether or not patterns exist, and this can lead us into a new area of discovering and even detection. Clause 4.1b of the bill seeks to introduce the words, the FIU may on its own motion or upon request disseminate financial information. This is new to this bill, and the words on its own motion or upon request is being, or are being included. That's in section 8.3 of the bill. But if you go to section 8.1 of the bill, which outlines the functions of the FIU, it's saying here, the FIU, and this in its pure form, the FIU shall be responsible for the collection of financial intelligence and information and the analysis, dissemination, and exchange of such financial intelligence among the law enforcement authorities and so on. So if it is that clause 8.1 is saying the FIU can disseminate, why is it in 8.3 we're now saying it can disseminate on its own motion? I'm confused. Because 8.1 is giving the FIU the authority to disseminate. That clearly says so. It says it shall be responsible for the collection of financial intelligence and information and the analysis and dissemination. So if the FIU in 8.1 is saying that it can disseminate, why do we need to now include the words on its own motion? And even if you want to include it, it should be included on the functions of the FIU, which is on 8.1, and not in amending 8.3. Clause 4D of the bill seeks to amend or make amendments to Section 17 of the Act as it pertains to publication of countries that are not fully compliant with anti-money laundering and counter-terrorism. The law says, 17.1, the FIU shall publish as frequently as necessary by notices in the Gazette and in at least 2 newspapers in daily circulation in Trinidad and Tobago, a list of countries identified by the Financial Action Task Force as jurisdictions that have strategic anti-money laundering and counter-financing terrorism deficiencies. So that's the new amendment, and I'm good with that. The part I have a little bit of concern with is lower down. It says here that according to 4D subsection 2, the FSRB, which is a FATF-style regional body, is also publishing a list. Now, if FATF is publishing a list, and FSRB, which is a FATF-style regional body, which is saying here that it is modeled after FATF, then if FATF is presenting a list, why does the FSRB have to also present a list? I'm confused. And if both entities are submitting lists and publishing it, then which one should we really be paying attention to? And I'm really confused. If it is that we're following FATF, then let's go with FATF. And if it's the FSRB, but FSRB is functioning like a FATF-style body, that's the acronym for it. So then why the need for a second list? I'm unsure. Clause 4E of the bill, and this was referred to by other speakers, and it pertains specifically to a warrant being issued to acquire information from a listed business where the listed business refuses to give consent to access the information. So that you want to get information from the listed business, they're refusing, you go to court and a warrant is issued. I'm okay with that up to there. But where I have the concern, and probably the legal minds around me can help me here, is where it said later on that Amendment 2B for this clause says, a warrant under subsection 2 may include the requirement to provide a police officer with any information or any explanation on the information. I'm unsure if a warrant can mandate someone to explain something. And can you imagine a man being served with a warrant, his mental frame or his state of mind, and then being told that he has to answer? I would think in a situation like that, if I was ever placed there, I would want to be cautious about what I say. But then a policeman cannot force me into an explanation due to the presentation of a warrant. And so I would say if the warrant is necessary, it's a warrant to search the premises probably or collect information, but the explanation cannot be included. It cannot be included. I have not ever heard of a warrant being issued for someone to explain. So I'm concerned about that. And the thing about it is, you know, many of us refer to the Constitution and Sections 4 and Section 5 of the Constitution. But as one person rightly says, if you understand what the Constitution is really a contractual obligation between the state and the citizen. That is what the Constitution is. So if it is that you are doing something unconstitutionally, then you are violating the contract. The Customs Act. Clause 5. Madam President, Clause 5 of the Customs Act seeks to really introduce an extension of time period for record keeping for those who import and export merchandise. The Honorable Attorney General was very correct in saying that the tax laws of the country requires you to hold your documents for 6 years. And so, if it is that you're now asking those who import and export to hold their documents for 6 years, I'm okay with that as well. because all you've done is harmonized, and then you're allowing a paper trail to be used in the event that there's a query or concern. I'm okay with that. The problem I'm having with this clause is where it says, I think in 23.2, where the controller has, this clause seeks to introduce an addition to the Customs Act 23.2b, which states where the controller has adjusted the value of goods previously imported up to 6 years prior. And if the importer has not paid the new dues, then his future shipments can be withheld. And I think Senator Mark also addressed that. If it is that you want to keep or ask the importers and exporters to keep the records for 6 years, I'm okay with that. But to say that we can go 6 years backwards and interfere with a valuation then, and then hold a business person, hold him to ransom if he has not appealed the matter for future shipments to come, that timeline can't be right. Because that is anti-business at a time when our economy needs business. And so I don't think any member of the private sector would really subscribe to a penalty being assigned to them for an invoice that's 6 years old. It speaks to the deficiency of the customs unit. And if it is that the customs unit require more time than the 1 year, 1 year, 2 years, fine. But it can't be 6 years. It can't be 6 years. It can't be, and even this aspect of the bill didn't go on to say whether or not the time period will be applied retroactively or post the proclamation of the bill. So, okay, I thank you for the correction. So therefore, it's saying now that if it's not said retroactively, then it's saying that the only time this is possible is in what, 2023? That if you come back to 6 years, then you'll be addressing the time period now. And that's just too much of a long time to hold someone to ransom and then saying that you have to pay the dues and say if you don't pay the dues and you don't appeal the matter, we're going to take your future shipments. I don't think that's right. That's a police state. I don't think that's right. And so while I agree with the 6 years for record keeping, I'm asking the government to reconsider that time period for readjusting the value of the merchandise that you want to tax. What about if the supplier of that shipment who's external to Trinidad and Tobago goes out of business or has been out of business? Then how do we get the information to support it? And in the absence of information, you're going to hold the future shipments. Who's going to pay the demurrage and the detention fees at the port? I'm not sure who's going to do that. And so that is anti-business. And so, Madam President, it brings me to another point with respect to the Customs Act. One area of the Customs Act seeks to introduce, Clause 5C of the bill, seeks to amend Section 45 of the Customs Act with respect to the prohibition of items to be imported. These include firearms, ammunition, bulletproof vests, firearm accessories, and including lasers, lights, holsters, scopes, etc. And again, I would like to agree with this amendment to say that, okay, we need to exercise caution and we need to restrict the importing of these items. But I want to read an excerpt from an article written by Bloomberg Businessweek on January 30th, 2018. Now remember, this part of the bill is seeking to restrict the importing of firearms and ammunition and its accessories. And it's entitled, Venezuelan Pirates Rule the Most Lawless Market on Earth. Venezuela and the island of Trinidad are separated by only 10 miles of water and bound together by most lawless market on earth today. Playing out at sea and on the coasts, it's a rolling arbitrage of food, diapers, weapons, drugs, and women between the desperate and the profit-minded. Government is absent. The article is saying this, and this was from an investigative reporter. And it goes on to say at the end of it, it says, with the help of a local investigative reporter, I was able to speak with a Trinidadian smuggler, and I don't want to say his name. It says here that he was well-spoken, a man who appeared to be in his 40s. And look what he says here. He says, they asked whether they should kidnap you, meaning the reporter. He delighted in shocking me by quoting the prices he gets from criminal gangs for automatic weapons acquired from Venezuelan armed forces. $7,000 for an AR-15, $40,000 for an FAL, I don't know what it is, and $2 around for military-grade ammunition. So it's saying that while you're trying to strengthen the Customs Act and prohibit the importation of firearms and ammunition, the source is not really there. So in strengthening the law, you're not really plugging the artery for which these ammunitions are coming into the country. So we can strengthen the law for the sake of compliance, but will it have an impact? Will it have an effect? And I doubt it very much, given there's an unregulated port and border for which access to this equipment can be attained. So whether or not the amendment in the law will bring about the desired result, again, I question that. Senator Small raised the argument about the firearm user's license and how much ammunition they can bring in, how much accessories, whether or not it can be, whether or not they can bring it in what quantities for the purposes of resale. So I'm not going to get into it, but I think it's an area that needs to be addressed. And the last part of the bill speaks of the amendment to the Exchange Control Import-Export Order and the Exchange Control Act that speaks of bearers of negotiable instruments. And it's saying here that there was probably a loophole with respect to funds coming into the country with respect to this instrument. And again, I commend the government for recognizing that this is an area that needs to be addressed, and so brought the necessary law to plug this hole, this loophole. Whether or not it was from the FATF report or not, at this point in time, it's a loophole that needs to be addressed, and the government is addressing it. So I respect that, and I support it wholeheartedly. However, all that the new law is saying is that if someone seeks to bring in a bearer of a negotiable instrument that has the value of 5,000 US or exceeds 20,000 TT, it needs to be disclosed. And while I support it, I would like to say that disclosure by itself is insufficient. Because all that you've done in declaring it is to say that I have it. And once you've done that, you would have completed or fulfilled your end of obliging to the law. What is being done with this money? Where is it going to be deposited? Are you leaving the money, or are you investing it into an asset? Is it going into a financial institution? Do you have it with you for precautionary reasons and taking it back out of the country when you leave? A disclosure doesn't tell you that. All it's saying is I have it. What is going to be done with it, we don't know. And therefore, if funds are going to be entering into the country via this form, then it needs to be tracked. It needs to be traced. And so, for what use would the money be put? Then you should also say it. For whether or not if you choose to take it back out of the country when you're leaving, you should also say that. And if you're bringing it in, disclosure is insufficient. Let's get approvals to bring it in the first place. That way we would know where the funds are going. A disclosure of having it with you is insufficient in my mind. So while you're saying, yes, we are correcting or strengthening the law, then what is being done with the funds, we don't know. And that needs to be addressed in my mind. So, Madam President, as I wrap up, I would just like to, in terms of summarizing what I've said before, I support the clause, I'm supporting the amendment of clause 2 with respect to removing the inability to cooperate. Let's cooperate. I agree with that. With respect to clause 3 and money laundering, and the offences now being laid summarily or indictably, I'm unsure as to whether or not that would bring about an effective change, especially when we have an occurrence of roughly 3 per day, 3 suspicious activity reports per day, and we are unable to prosecute and convict in the existing system. With respect to clause 4, I agreed with the trends and typologies to be used to demonstrate the relationship or to unearth relationships. However, with respect to the dissemination of information on its own motion, I think that was adequately addressed in 8.1 of the FIU Act. The publication of countries, I said I'm unsure of the difference in the list between the list published by the FATF group and the FSRB. And with respect to 4E, where a warrant is being issued to collect information, I have great concerns with a warrant empowering a police officer to acquire information in the form of an explanation. I have a concern with that. And with respect to Clause 5 in the Customs Act, I agree with the harmonization of the 6 years for record keeping, but totally disagree with the ability of the controller of customs to adjust the value of an invoice 6 years old and to hold future shipments at ransom if unpaid. And with respect to Clause 6 of the bill, I'm saying with respect to bearer negotiable instruments, while I commend the government for bringing it here and plugging a loophole, disclosing it is insufficient. Where the funds will be deposited and the use of the funds and the approvals by the relevant authority to bring the funds into the country should also be sought. With those few words, Madam President, I thank you.
Minister of Trade and Industry.
Thank you very much, Madam President. And let me say that I'll be pretty short. I just feel as Minister of Trade and Industry that I must respond to some of the comments made. Let me start by thanking,
Madam President, in accordance with Standing Order 14.5, I beg to move that the Senate continues to sit until the conclusion of the contribution of the member, and then the completion of the matters to be raised on the motion for the adjournment.
Honourable Senators, the question is that the Senate continue to sit until the conclusion of the contribution of the Minister of Trade and Industry and the completion of the matters to be raised on the adjournment. Those in favour say aye. Aye. Those against say no. The ayes have it. This Senate will continue to sit until the conclusion of the contribution of the Minister of Trade and Industry and the matters to be raised on the adjournment. Minister of Trade and Industry.
Thank you very much, Madam President. Again, let me start by thanking Senator Taurel Shrikissoon for his out-front support for the bill. I know, yes, he has indicated his out-front support. The senator did, in fact, raise some concerns, which, and also the other senators on the independent bench. Indeed, none of these persons who spoke from the independent bench have indicated their lack of support for the bill. But there are concerns which were raised, and I'm sure that the Honourable AG will, in fact, address these in his winding up. The problem, of course, came with the opposition side. And let me just respond to Senator Saddam Hosein, who seemed to be so concerned as to whether or not we will, in fact, be following the money on a number of issues. And Senator Hosein, let me again give you the assurance, Senator Hosein, that we will, in fact, be following the money on a number of issues, including, number one, the spurious Highway to Point Fortin $7.2 billion project. We will follow the money on that matter. We will follow the money in terms of the bid ringing in the $1.6 billion Wassa wastewater treatment plant at the Beetham. We will follow the money with regard to the high construction costs of the Couva Hospital, with $400 million being spent on consultancy fees, 40% of the total project costs being spent on consultancy fees.
Minister, please. Members, please. We've had a fairly calm sitting, and let us just continue in that vein until the contribution of the Minister is over. Continue, Minister, please.
Again, we will follow the money on Squandermania at Sport TT. We will follow the money on all of the overpriced construction projects under the last government. We will follow the money on the feeding frenzy at the AG's office. And I can go on and on and on. But, Madam President, I'm not going to be long. But I will not be in the house next week, as I'll be on grandma duties. I'm over the moon. I'm over the moon. I couldn't help but say that I had a grandson who was born just before we came to the house today. Thank you, everyone. It's a boy. Okay, let's get back to, and I will be short because we were up all of last night. But I want to congratulate the Honorable AG. I know there was... okay. I want to congratulate the Honorable AG. And I know you have concerns, many of you on the opposition side, that there was not enough depth to this first bill, which is the Miscellaneous Provisions Bill 2017, dealing with amendments to a number of pieces of legislation. But I give you the assurance that this is only one part of the continuing efforts by our government to fight corruption and to address all of the transnational issues that are in front of this country at this time. And so that I say to you that there's going to be a suite of legislation dealing with anti-corruption matters, and this is going to be brought before the House within this parliamentary session. So, and we spoke about Senator Shrikissoon brought up the issue about the Bloomberg report. We are concerned. We are all concerned, and hence the reason why this government is openly committed, and we have said so to the public, that we are committed to dealing with the scourge of crime overall. We are committed to dealing with money laundering and the financing of terrorism and all of the associated ill and horrific events that beset us at these times. And we are committed to covering these offences and dealing with these matters from every angle. And this is what this first piece of legislation is about. We are going to be very, very, very focused on following the money, whether or not the money is obtained through money laundering, narco dealing, human trafficking, terrorism, or general criminality. This government is committed to dealing with these issues. And thus, again, this is a continuation of the work which we did between 2005 and 2010. And I want to correct Senator Khadijah Ameen that the Financial Intelligence Unit Act was in fact put forward by our government in April of 2010. Am I right, AG?
Madam President, just 42.9.
Yeah, you can correct after. But
no. I'm asking a standing order.
No. And when I'm finished, you could have but it was in fact put forward. Yes. AG, I'm correct? Yes, April 2010, the Financial Intelligence Unit Act. And there were several pieces of legislation which our government did in fact, the previous PNM government brought into force, that is the Anti-Terrorism Act, and also the Financial Obligations Rules, and the Proceeds of Crime Act, and so on. I'm not going to deal... As you speak, and Senator Wade Mark, as you've raised your voice, let me address your concerns. You said that this piece of legislation was draconian, and it was very cruel, and very... that there was very cruel punishment attached to it. Those were your words. You said it was very oppressive, and so on. And I don't think... the AG has now corrected me. Act 11 of 2009, the Financial Intelligence Unit Act, under a previous PNM government. Thank you, Honorable AG.
Oh, I thought you were talking about cruelty.
Yeah. So you were speaking about my disappointment. Yeah. And my disappointment is with you, Senator Mark. My disappointment is with you, that you do not understand the complexity of money laundering and all of the other transnational crimes that are before us. And he's making light of it, Madam President. And these are very serious issues. I place on record that the opposition seems to be making very light of some very serious transnational crimes which are facing this country, and which are impacted, and all of these issues are in fact impacting on the government's ability to attract investments. This is a very, very interconnected world, and therefore anything that happens in this country hits the international scene immediately. And to make light of this matter and to consider it and to treat it in such a trivial manner is unpardonable. Unpardonable and unforgiving. Unpardonable. So that I want to... And in fact, the seriousness of it was raised by Senator Taurel Shrikissoon when he highlighted the fact that in December, the EU blacklisted us as a tax haven. That is a serious matter. And this is why we've had to bring these pieces of amendments to several pieces of legislation. We are committed. And that's the point that I'm making. We must deal with the issue of money laundering once and for all. Once and for all. And again, because it is connected with narco trafficking and all of the other areas of concern. And it is the jurisdiction around the world are dealing with implementing new laws and determining new methods to combat and to reduce money laundering practices. And we must not be a stranger to these acts at all. As I said, we are all interconnected, and several jurisdictions have gone up front, and they've, in fact, and as I said before, they're implementing new laws and legislations, and new laws and legislation and regulations and governance arrangements, and Trinidad and Tobago will not be a stranger. We must, in fact, be committed. All of these negativities, in fact, affect all of the citizens of Trinidad and Tobago, all of us in our everyday lives. And also, it is also impacting on our economy in a very serious way. And Senator West did, in fact, bring up the whole question of its relation on taxes and tax evasions. I'm not going to go into that. But indeed, Trinidad and Tobago is a developing country. And we have to comply with Global Forum and international best practice and all of the compliance standards in finance and taxes if we wish to grow and if we wish to attract investments and if we wish to trade internationally. And I'm going to speak a little bit more at the end of this. So when Senator Ameen speaks about witch hunting and she brought up the issue of sovereignty, let me tell you, there's no question of sovereignty when you're thinking of criminal activities at all. The criminal mind does not think of borders. They don't think of sovereignty. They penetrate every border across the globe. So sovereignty has no issue when we speak about these transnational crimes. Absolutely no issue at all. And so therefore, I don't want to say that it's naive, but the fact is, yes, sovereignty deals with the protection of your citizens, but criminality knows no borders. They know no borders, and therefore it's a non-issue, the question of sovereignty in a case like this. Absolutely not. So some of the provisions in the bill we've already addressed, and it's no point bringing up that. But the whole question of freedom, the freedom of exchange of information must happen. And to the extent that spontaneous exchange of information must be allowed to take place. Because some of the matters are so serious that you have to deal with it as it comes up. And therefore, the law must make provision for the spontaneous exchange of information. We are required to be globally compliant, and I made that point already. And for example, with FATCA, the free exchange of information was necessary to ensure that compliance existed between the Trinidad and Tobago and the US. I made the point again that all of these features are absolutely necessary in today's world. And it is the exchange of information between jurisdictions that will help to keep citizens safe. Not only citizens in Trinidad and Tobago, but citizens across the globe. And as legislatures, we must know the importance of these types of exchanges. And again, I make the point of the seriousness of money laundering and the number of cases that are already before us. My understanding is that there are about 17 cases before us and about 54 charges before the court. So this is not a trivial matter. And they must be dealt with. Some of these cases have been before the court since 2012. And we therefore have to put all the provisions in place to deal with these matters. The point was made again about deleting Section 22(2)K again, which dealt with the refusal of the request for the giving of information. And again, I want to make the point that this is in keeping with global practices to allow for the exchange of information to ensure that the criminal offenses are in fact abated. It is a reciprocal process. You're going to have foreign criminals entering Trinidad and Tobago and committing crimes, and we are going to be forced to request information to deal with the matters. There's a strong element of reciprocity in all of this, and we are obligated to deal with it. There was a concern about Article 5, Clause 3, which deals with the fines, the very serious fines of 25 million, very high fines of $25 million and to imprisonment for 15 years, now being amended to a person being who commits an offence under Section 5 being liable both on summary conviction to a fine of $25 million and to imprisonment for 15 years, and B, on conviction on indictment, to a fine of $50 million and to imprisonment for 30 years. And again, I want to support the AG, again, with the double approach, the fact that these offences will be triable both on summary conviction and on indictment. And it is that the AG, at least in the lower house, did note that it is the DPP who will determine which procedure each case would attract. And I bring to the attention of this Honourable House that this new clause is similar to many in other jurisdictions. It's not at all something that we have come up with. It's certainly in the UK legislation where the offence of money laundering can in fact be tried on either side. And I want to say that I want to bring up one point with regard to the number of cases before us, and I should have said it. We had introduced before the question of the preliminary inquiries, and it's in 2017 that the Honourable AG had brought to the Parliament the indictable offences pre-trial procedure, which sought to abolish preliminary inquiries and to provide for the pre-trial procedure in respect of indictable offences and for ancillary matters. And again, it was heavily disputed by the opposition, and of course, no solutions were offered. And I want to say this, all that we speak of today implies that this is a matter. You speak about the justice system. Several of you on the opposition side brought up the fact that the justice system is not ready and so on. And we're not saying no to that. But the point is, when we do in fact bring forward legislation that is going to help the justice system and to move these cases along, we will need the support of the opposition. And this piece of legislation, I'm sure it will be brought back to the Senate sometime soon, Honourable AG, and we expect, you complained about the justice system, we expect that we will in fact have your support, this is the opposition, when it is brought back to the Senate sometime soon. Again, I know that there was concern with regard to Section 23 of the Customs Act and the question of the substitution of the 1 year with the 6 years. And I want to say that as Minister of Trade and Industry, again, because of the whole scourge of money laundering, and listen, we're not dealing with $20 and $1,000 offences. I mean, in terms of the amount of money that is being moved and so on. You're dealing with large offences, substantial offences, and therefore I do not consider as Minister of Trade and Industry that in fact that this is an onerous term at all. And again, the point was raised about how long the importer is required to keep his documentation. I take no issue with the fact about the 6-year period. In any event, if you're holding records with tax records for 6 years, I see no problem with it holding on to customs documentation for 6 years as well. This is the extent to which we have to go, and it's very important, and I support the Honourable AG. I also support the inclusion of the question of appeal within 6 months. There is that process that's been allowed for, the process of appeal within 6 months. That's ample time, and anybody who feels that they've been dealt with harshly, there's a 6-month period to bring the matter before, and therefore Again, I do not consider this to be draconian at all, and there must be consequences for committing all of these terrible crimes as well. And I also do not consider it draconian in terms of the refusal for the delivery of subsequent shipments by the importer. It is not draconian having regard to the severity of the offence that we're dealing with. There's another, the opposition weighed heavily on the question of the 3/5 majority, and there's absolutely no clause or right established in the Constitution that is going to be infringed. And in fact, this 3/5 majority is absolutely not needed. There are no provisions in the bill which encroach on the rights of the citizens of Trinidad and Tobago as stipulated in the Constitution. There's absolutely no encroachment. There's nothing in the bill which can be construed as requiring any person to give any information which may incriminate him. That is well laid out in Clause 4 of the bill. It is, if I can quote again, nothing in this section shall be construed as requiring any person to give any information which may incriminate him. So there's absolutely no infringement on the right of any citizen of Trinidad and Tobago. Absolutely. So that the whole question of the 3/5 majority, as I said, does not arise at all, and there's absolutely no trampling on anyone's private or personal right or so. I mean, what this calls for is for persons, importers, and so on, to abide by the law. It is a very fine line here. You either abide by the law or you don't abide by the law. And therefore, and sometimes the comment is made by many citizens of our country that we're concerned about the discipline in our country. You speak about the watchwords of our country, discipline and production included. And really, we have to take these matters seriously so that even in terms of importing, exporting, and in the conduct of one's business, discipline is important. Discipline is absolutely important. People must abide by the law, and therefore I can take no issue with this whole question of your suggestion. Sorry, I take great issue with your suggestion that a 3/5 majority is required. People must make their declarations properly. You're importing goods, businessmen are importing goods. You make your declarations. You'd make your declarations truthfully and fairly. All of these things speak to transparency, honesty, and so on. Declarations by all importers must be made. All of these matters of under-invoicing, I, as Minister of Trade and Industry, will not support those kinds of activities at all. So anybody who wants to hide money in other people's name and under-invoice and all that kind of nonsense, they're the people who have to worry. They are the people who have to worry. What we have to worry about is those persons who are offended. You see, the offenders, they are in trouble, and this is what we are dealing with. But we have to speak to all of the people of Trinidad and Tobago who are in fact offended by the scourge of money laundering and all of these other transnational crime. It's a thin line. You're either supporting the opposition, you're either supporting the offender or the offended. And I can tell you on this side, we are supporting those offended. As Minister of Trade and Industry, as Minister of
Senator Mark, please refrain from what you're saying. Okay? Minister.
Thank you. Again, I make reference to the Bloomberg report and many other reports that may have been out there in the public domain. And we must all be concerned about our country's reputation. And our country's reputation will be affected by money laundering and terrorist financing activities and other criminal activities if we do nothing about it. And I go back to our commitment to deal with these matters. Our country's reputation is important for our revenue streams, for sustainability, for economic growth, for diversification, which we talk of all the time. You all speak about it. So for business process outsourcing, for all of these, all of the areas of diversification which we speak to. So therefore, we have to be serious about our country's reputation. We have to, and I expect each of you, each of you on the opposition side, to think about this within your contributions, your country's reputation, your economy, the growth, our sustainability, our ability to upkeep all of the social programs. When our revenue streams fall, all of these programs are impacted. So we must be concerned. And it is that no investor will invest in our country. And I'm talking about local investors, foreign investors. No investors will risk putting their money into this country if we are not attempting to deal with fraudsters and money launderers, if we are not dealing with all of the anti-terrorism activities that appear to be out there. We cannot allow these activities to go unnoticed. Our reputation is at risk, and it is damaging if we do not deal with these matters. So we need to maintain some level of confidence, investor confidence, confidence in our country, confidence by our citizens, and so on. As I said, these things affect our financial system, and I think the point may have been raised earlier, and it is therefore critical that they are dealt with. I want to say that in the Ministry of Trade and Industry, all of these matters are in fact very impactful on our economy and by extension, as I said before, the investment climate and the trading environment. We are trading with our global partners. All of us through the WTO are pretty much on a virtual trade facilitation system and platform. And therefore, we must ensure that there's compliance, there's collaboration, if we do in fact want to increase our trading activities. And so that in the Ministry of Trade and Industry, we are continuing to come up with policies to, in fact, improve our trading activities and to attract investments to this country. And therefore, we must support the Honourable AG and the government in bringing forward these matters and dealing with them. Bills like these are absolutely necessary to uplift our profile and to ensure that our country remains a very secure and stable country where the law works. That is what we are concerned about. So that, again, let me just say that we, in concluding, the work of the Ministry of Trade and Industry and continues to be very, very, very important to our overall economic growth and the health of our economy. I want to say that there are a number of systems that we are working on, policy arrangements that is going to assist with improving the trade and investment environment. You would have learned, Madam President, and I've spoken about it over and over, about the single electronic window. Out of that single electronic window system, we are in fact dealing with the customs and the entry of goods into Trinidad and Tobago, the exports of goods out of Trinidad and Tobago, the whole question of an integrated risk management system to ensure that our trading system is in fact very, very efficient. We are reviewing all of our trade laws and ensuring that we operate in a trading environment that is transparent and that is within the law. Madam President, we are, again, the operationalization of the port scanners, which we trust will be in place in a matter of months or so. Our electronic funds transfer framework, which ensures again, the very transparent e-payment systems. We are, in fact, facilitating all of these improvements, again, to fix our incentive framework, to fix our investment framework and our trade framework as well. And therefore, very importantly, the whole question of compliance remains on the front burner. We have to ensure that we do everything to ensure that we are globally transparent and compliant. I can't speak anymore about the interconnectivity and between countries. and that anything that happens in Trinidad and Tobago today is in a matter of minutes on the international arena. And therefore, we will continue as a government, we will be resolute in bringing forward, continuing legislation to deal with following the money. We are resolute, as I said, in dealing with these matters and to try the necessary individuals in a timely fashion. As I said, if you're a law-abiding citizen, if you're a law-abiding company and you're doing what is right, then you will have no need to worry about these pieces of legislation which are now brought before the House, the amendments now before the House. Maybe I can't understand the concern and why the opposition won't support it, but as I said, as long as you are law-abiding, citizens or businesses, you would have no issue with all of these pieces of changes in legislation that we are bringing before you. If, however, there's breach of the law, and there's corruption and bid rigging and cartel behavior, or if you've gotten a bribe, or if you've gotten things through conspiracy, then you have every right to be afraid, and we are going to be dealing with you effectively. Those that are the loudest objectors, we have a concern. We have a concern, and therefore we take note, we are listening, and we are going to be dealing with all of these offenders. Madam President, I wish to thank you and give you the commitment of the Ministry of Trade and Industry, again, to improving our revenue streams in this country, to adding to economic growth, to adding to sustainability of our revenue streams and the overall economic strength of our country. Thank you so much.
Madam President, I beg to move that the Senate do now adjourn to Tuesday, 27th of February 2018 at 1:30 p.m. During that session, we will conclude the debate on this bill. And for your information, Madam President, next week Tuesday is the fourth Tuesday of the month, and by mutual agreement, we have decided to defer private members' leave.
Honourable Senators, before I put the question on the adjournment, leave has been granted for two matters to be raised on the motion for the adjournment. Senator Mark.
Thank you very much. Madam President, the matter that I am happy to raise this evening addresses the issue of revenue shortfalls that have been literally foregone owing to the absence of mechanisms in the quarrying industry by the government of the Republic of Trinidad and Tobago. Earlier on, you would recall the Honorable Minister in the Ministry of Finance speaking about the $10 billion deficit and saying to us in this Honorable Senate that we must do everything in our power to collect our taxes. And I wish to ask the Honorable Minister of Energy and Energy Industries, why between 2001 to 2015, scores of quarry operators have been operating illegally in our country. And once you are operating illegally in our country, you do not pay royalties, Madam President. And the evidence is now showing that there are scores of individuals who have been operating in different parts of our country without any licenses, denying the country in the process, denying the Treasury in the process of much needed revenues. Based on a minerals policy issued by the Ministry of Energy and Energy Industries sometime in 2015, we were told that just under $150 million remain outstanding by quarry operators. This is not to mention or to include their failure to pay corporation taxes, their failure to pay green fund levy, their failure to pay business levy, as examples. But there were some changes in the regulations, we understand. And with those changes, there were increased fees. License fees were increased. Bonds for performance and rehabilitation were also increased. And we are advised, Madam President, that just in terms of license fees and bonds, performance and rehabilitation fees or bonds, the country is losing about close to $140 million between the last few years. So here it is. The external patient program is under stress. The school feeding program is under stress. You have a lot of challenges in terms of cutbacks in many ministries and agencies of state. And Madam President, we have a quarry industry that is owing the taxpayers of this country and the Treasury and the Consolidated Fund close to $500 million. What is the government doing about that? It is money that we have to collect. Why is the government not taking steps, Madam President, to regulate the quarrying industry by issuing licenses to those illegal operators? When I say illegal operators, Madam President, those are people I'm talking about who have had licenses. Their 5-year period up. They have reapplied, and they are still awaiting new licenses. So it's not to say they never had licenses. They had. But those licenses expired. Then we have a new category called new applications or applicants. And we understand, Madam President, because they have not been able to be given their license for whatever reasons and challenges, they too might be there engaging. We don't know to what extent they are, because the ministry is under severe pressures as it relates to its mineral division. Madam President, would you believe that the Auditor General, in his 2016 report to this Parliament on the accounts of the Republic, was able to reveal that the quarrying industry and the regulator for that industry, that is the Ministry of Energy and Energy Affairs, were not able to establish weigh bridges to measure production outputs in that industry? Everything, Madam President, is being done on the basis of the goodwill of the extractors or the owners of these quarries. So here it is, Madam President, our environment is being destroyed by these quarry operators. And we are not collecting royalties. We are not collecting corporation taxes. We are not collecting green fund levy. We are not collecting business levy. And then in terms of licenses and performance bonds and rehabilitation bonds, we are not collecting those fees. So I call on the Honorable Minister of Energy and Energy Industry. What is the government doing? We learned at a meeting just a couple of hours ago that sitting in the LRC of the government is a bill called the Miscellaneous Provision Illegal Quarrying Bill. enforcement quarrying bill. That is what we were told at a public hearing recently. That bill has been with the LRC since 2016. Because, Madam President, there are criminals operating in the quarrying industry today. And they operate with impunity because of the inability of the government and its agency to enforce the law against those operators. And they are stealing from the public purse. They are not providing the royalties because they are doing it illegally, Madam President. So the reason I'm raising this matter today is because I know Trinidad and Tobago is in a very tight fiscal revenue situation. And Madam President, we have sitting in this country millions, hundreds of millions of dollars to be collected. And I want to know what the Ministry of Finance is doing about this. I want to know what the Ministry of Energy and Energy Industries is doing about this. Rather than take advantage of poor people where they cannot get proper services at the health sector level, where the school feeding program, as I said, is under attack, as an example. Madam President, where today, as we speak, cancer patients, through that external patient program, is under pressure. So I call on the Honorable Minister of Energy to tell this Parliament what measures, what measures are being taken. Thank you very much, Madam President.
Minister of Energy and Energy Industry.
Thank you very much, Madam President. Madam President, this is I must admit, is an extremely timely motion on the adjournment. The Ministry of Energy, through its Mineral Division, supervises 90 active quarry operations, the majority of which are in northeast Trinidad, where the most prevalent type of material mined is sand and gravel. Other types of material mined includes blue limestone in the northern range, yellow limestone, clay, and red sand in central Trinidad, and the site in Tobago. That is in the Studley Park Quarry. The operators of these mining operations are required to submit quarterly quarry returns of mining data and evidence of royalty payments to the ministry. Verification of the information is achieved through site visits conducted by personnel from the ministry's internal audit unit and the minerals divisions. The operators' books and records are perused, checked and verified to ensure data correlates with the returns. Where there is a liability to the state, the operators are so informed and requested to settle the outstanding amounts. For the renewal of mining license, the operator is required to pay all outstanding royalty. Madam President, over the last, I would say, decade or so, the system seemed to have collapsed. And by assumption of office, as the Minister of Energy, I decided to take a focused look at the quarry industry because there is significant revenue leakage. I don't like to compare former regime with this current regime, but let me just quote a piece of statistic here. As a result of a greater focus on data collection and receivables management, revenue from this sector increased in 2014. Hear this. Oil price was costing $100. The economy was overheating. Right. Construction was in a boom. 2014. Under the UNC, the quarry industry paid royalties of a mere $1,398,000. Imagine that. I'm pleased to announce, despite our challenges, that in 2017, which is last year, in a downturn, minimal construction going on in the country, save and except a couple key projects, because of efforts we have put in place now, still in its embryonic stage, still has far to go, we collected 7,865,000. There's still outstanding a very large receivable of approximately $92 million in unpaid royalties by operators on state lands. Regrettably, $48 million, or half of that, is owed by the National Quarries Company. But what I think matters most, and I wouldn't call name because we're going after them, the other half, which is $40-something million also, there are 21 operators who owe more than $1 million in outstanding royalties. So if you take the other 40-something million, half of that is owned by 21 quarries, which are very large quarries. And if I only call the name, you will shudder to think companies of that nature could be owing the state so much money. But we have contacted them, and we tell them that is grounds for the termination of their license. And we are going after them in a very, very serious way. However, we have some challenges in the Ministry of Energy and Energy Industries in terms of staffing. Because as we speak, the Minerals Division is very understaffed. On the official establishment, there's vacancy of the Minerals Establishment, which was created by Cabinet in 1998 and 2000, calls for 1 Director of Minerals, 2 Senior Geologists, 1 Senior State Counsel, 6 Geologists, 1 Geoscience Surveyor, 4 Mining Inspectors, 2 Mining Survey Technicians, 2 Geological Assistants, 8 Clerical Staff, and 17 daily paid field crew. The current establishment is 1 Director of Minerals, 1 Senior Geologist, 1 Mining Inspector, 2 Mining Survey Technicians, 2 Geological Assistants, 2 Clerical Staff, and we have people on contract called Quarry Management Officers who are holding on temporarily. And what is so painful about this, Madam Speaker, is that, Madam President, is that the Ministry of Energy was given delegated responsibilities by the Public Service Commission, which empowered the Permanent Secretary to go out and recruit these people. We had advertisements out. We shortlisted the names. And lo and behold, the Public Service Association filed an injunction to block this. I spoke to the President General, Watson Duke himself, and I said, how could you do something like that and deny young geoscientists and geologists out there coming out of school, bright like a bulb, and deny them the opportunity to work in the sector? And hopefully, that injunction will be heard later this week, and we hope that it is thrown out, and we could go ahead with the recruitment of the staff. So, Madam President, there are challenges in the sector. Royalty payment, to me, is fundamental. I've raised it with the oil companies because we have instituted a royalty system for gas now. If you heard in the last budget debate, the Minister of Finance imposed a 12.5% royalty on gas. Because when you're dealing with a wasting resource, a non-renewable resource, the taxation system has to take place on volume and not profitability. And in any extractive industry, whether it's a coal mine in Pennsylvania or iron ore mine in Australia, you have to pay royalties, because when you extract that non-renewable resource from the earth, it is not replenishable. And anytime a company, I can make a concession on corporation tax. I can make a concession on any other form of taxation, a green levy. But the most fundamental principle of extractive industry taxation is the payment of royalty. Madam President, through you, I want to give the country this assurance that I have taken this matter very, very seriously, and we are putting steps in place to recover as much of this outstanding royalty as we can possibly do before we become very draconian and revoke the license of some of those quarry operators. I thank you.
Senator Obika.
Thank you, Madam President. And I must say it brings me no pleasure to bring this private motion, this motion on the adjournment, regarding the need for the government to properly explain the sudden resignation of the former chairman of the Economic Development Advisory Board and the potential adverse impact of the resignation of on the work of the board. Why I say that is because as a student and a practitioner of economics, it really is a sad day when a prime minister could decide not to listen to his advisors, so much so that the advisor decides that it's time to go. I quote from Express article on the 12th of January, Friday, article by Leah Sorayas, the president of the Trinidad and Tobago Manufacturers Association, Christopher Alcazar, in his statement yesterday said that Farrell's resignation, that's Terence Farrell, was a loss to TNT's diversification agenda. Now, this is from no other than the head of the Manufacturing Association. Now, if you understand the importance of manufacturing to our economy, especially our agro-based manufacturing sector, we would understand that it means jobs. So if the head of the manufacturing sector that says that there's an indictment on the diversification agenda of the entire economy, it means we can look forward to an even more bleak job situation worsening in this country. I want to look at some other examples. We have a former minister in the Ministry of Finance saying that nobody is talking about what the Prime Minister said. And he's in reference to the speech at the beginning of the year. Now, the speech of a Prime Minister at the beginning of the year sets the tone for the drive and the energy of the executive, the persons who sit opposite us and in the House, in developing and doing their work program. But when you look at an article written by Andrew Worrell in the Guardian of January 11th, 2018, a Business Guardian, he mentioned that it's smoke and mirrors. He said there's a tremendously deceptive aspect to some of the rhetoric of the Prime Minister. In the first instance, the Prime Minister's proclivity for listing development projects completed and or in progress is a great example of misdirection for one simple reason. How will these projects, as a form of significant capital expenditure, end up yielding any revenue for the state? Additionally, there seems to be an unhealthy obsession with building things for the sake of simply doing so. So what is the material benefit, basically, these people are saying? What is the material benefit to the economy? And the answer is none. When the times are hard, you should really focus your attention on matters that bring revenue. Now, the resignation of the advisory board chairman confirms the obvious, that the Rowley-led government administration, the economic policy is aimlessly adrift and is a massive failure. Now, the woeful economic performance that we have seen, 20,000 jobs lost, as attested by the central bank economic bulletins of 2015, 16, and 17, 20,000 jobs lost since they came into office, resulted from has resulted in mass suffering of the struggling classes of Trinidad and Tobago. The tax to recovery. The word tax has to be repeated more than recovery. In this case, wish economics has resulted now in a GDP which is below 2006 levels. We have regressed 12 years under this government. Now, the business community has complained ad nauseum about the paucity of the government, and the Minister of Finance has been reduced to scrapping publicly with members of the business community, heads of different sectors. The recent move by the government to increase the treasury bill limit, not for stabilization purposes, not for not for balancing shortfalls in cash in terms of timing, but rather for expenditure, will distort our debt profile significantly. And Dr. Farrell's citing of inaction by the government points to what we in the United National Congress have been saying all along, that the Minister of Finance and the Prime Minister are on frolics of their own. Yes. And they have no desire to heed expert advice. So the resulting decline in the non-energy sector, they always talk about the energy sector. What of the non-energy sector? That's where the diversification agenda gets teeth. There's nothing to show. And the decline is clear in the September of 2017 Economic Bulletin of the Central Bank. What the Dr. Rowley PNM administration has, they have one alternative: call elections now. In the words of that Calypsonian from Buenos Aires, Mr. Weston Rawlings himself, he said he calling them and he not getting no answer. But I could tell Mr. Crow, he ought to drive the flashy Benz all the way to Parliament to get redress. Just come to Obika and I will bring you his feet up. At a Seaman Point by Frisco Junction all the time. So there's a new normal in oil prices. The Prime Minister in his address at the beginning of the year, on the 7th of January 2018, is still focusing on the lows of $30 a barrel. That was 2 years ago, February. We are now approaching the end of February 2018, when the new normal is above $50. If you look at the EIA right now, you will see that the West Texas Intermediate spot prices are trending above $60 a barrel for even the lower price benchmark crude, which is the West Texas Intermediate. So the Prime Minister needs to get with the program. He is not living in the past. And also it shows that the Prime Minister is confused. In the same statement, he said, in these difficult times, government gets voluminous and divergent advice from a variety of quarters, none of which is without some element of negative side effects. Well, obviously, that's why you have to run the economy. You don't run the economy. It's not a wishful thing. You wave a magic wand and things happen. But obviously, we could understand his problems, because now he has forced, it's called constructive dismissal. He has forced his advisor to resign. The advisor himself, Terence Farrell, Dr. Farrell, said, I have resigned because I am not satisfied with the progress that the EDAB has made under my stewardship since its inception 2 years ago. This is a man fed up and frustrated, as the title of the article, on Thursday, 11 January, in the Express. Yes. Now, let's go to the diversification agenda. The TTME already laid waste to the diversification agenda of this government. Laid waste it. So if the TTMA can do so, and we have been warning the government ad nauseum, here comes again another warning. Now, the Minister of Trade is now left, pity the Minister of Trade, to scrape up a few dregs to report investment of less than $400 million US, both in local and foreign. Whilst under the People's Partnership government led by the Honorable Kamala Prasad-Bissessar reported over $5 billion US only in foreign direct investment. Wow. And I said at the beginning, it grieves me. I get no pleasure in bringing this forward, because right now, if you look, the trade policy of the country has lapsed as of December 31st, 2017. The government of Trinidad and Tobago is following no trade policy at the moment. We are a ship rudderless, motionless, and we are the whims and fancy of the ocean. This is a sad day. No trade policy. Now, I heard the Minister of Trade talking about policies. I'm not sure if she needs to check back the ministry. The PS probably misinformed. The policy has lapsed. I'm sorry for... The workers in the ministry are good, but maybe they are not resourced properly under this government. The last policy was done 2013 to 2017. We know who was in power in 2013. Now let's look at different sectors. Sports, failure. Tourism, failure. I'll come to the details shortly. Interconnectivity to the Tobago economy, failure. Managing petrotrin and fake oil, failure. Gas duty poor negotiations, CNC fighting with NGC, another failure. A Prime Minister must never circumvent his executive and go and negotiate. He should be the last resort. Farmers' assistance,
Senator
failure.
Obika, your time is
No,
up. Senator
Minister, okay, thank you very much.
Minister of Planning and Development.
Thank you very kindly, Madam Speaker. Madam Speaker, I'm very happy to be here to respond to, thank you, to what I thought would have been a motion as described by the order paper, but obviously the senator went off on a frolic of his own. Madam Speaker, before I go into, Madam President, before I go into the details of my response, I just wanted to say that I thought it would have taken Senator Obika a little longer to become as jaded as his leader, Senator Mark, but obviously it's taking a much shorter time to become jaded and to become a peddler of misinformation and improper advice to the public of Trinidad and Tobago. And Madam President, we on this side have become so accustomed to those who are opposed to us on the other side speaking flawed logic, as my colleague has said, that I was really taken aback that in less than 2 months, Senator Obika has already joined that team in such a deep-seated way that his logic has become flawed, that he has joined the group that leads to fake information, to deception, to deceiving the public. It is very, very amazing to me. As a matter of fact, I was very surprised that he did not talk about the $400 million that was misused by the Ministry of Sport, that he did not talk about the $7 billion that was spent on a highway that is yet to be finished and is being finished by us, that he did not talk about the situation that has led us now to be developing an energy policy that is really to the benefit of the people of Trinidad and Tobago and not to the benefit of the oil companies. Because under the last administration, all they did was try to ensure that the oil companies took and took and took from Trinidad and Tobago, whilst they spent all the money, so much so that today we are still in overdraft at the central bank, Madam President. Madam President, we are in a situation today, and if Senator Obika were honest, he would stand and be able to say, Madam President, if Senator Obika were honest, Madam President, if Senator Obika, I repeat.
No, Minister, please. I would ask you to rephrase what you are saying because you may be implying improper motives to the Senator. Senator Obika as well, please, if you want to invoke a standing order, there's a proper way to do it. Shouting from your seat will not do it. Okay? Continue, Minister.
Madam President, if Senator Obika were being fair to the people of Trinidad and Tobago in the discharge of his duty, he would admit that the situation in which we find ourselves is totally on the shoulders of the Kamla Persad-Bissessar administration. And Madam Speaker, if you would allow me, under Standing Order 4211, I would like to be allowed to read. Thank you very kindly. Madam President, Dr. Terence Farrell resigned on the 8th of January 2018 by letter to the Prime Minister. His statement on resignation as chairman of the Economic Development Advisory Board is as follows. I speak for myself and not for the other members of the EDAB, who are all independent professionals and can therefore speak in their own right. I have resigned because I am not satisfied with the progress that the EDAB has made under my stewardship since its inception 2 years ago. That assessment is personal. I try to set high standards for my own performance, and I do not think I have been able as chairman to attain those standards. In my view, the macroeconomic, developmental, and diversification challenges facing this country are serious and require urgent, concerted action based on sensible plans, which have the highest priority and should be implemented with focus and resolve. I had indicated in a newspaper interview when I took up the responsibilities at the EDAB that I did not expect that all its recommendations would become policy and be implemented, but that by my own standards, a reasonably high percentage should be. I have not been able to achieve that. It is not that the EDAB has done nothing. It has submitted the following to the government. 1, in accordance with our primary mandate in our terms of reference, a draft diversification strategy and roadmap was submitted for consideration in March 2017. 2, the following advisory notes were submitted, responding to the declining revenue scenario, tripartite discussions on adjustment, accelerated deepening of relations between Trinidad and Tobago and Cuba, establishing a heritage fund, preliminary proposals for the pursuit of mutually beneficial opportunities between Trinidad and Tobago and Venezuela, revisiting current macroeconomic policy management, engaging the Trinidad and Tobago and West Indian diaspora, encouraging business process outsourcing and global ICT-enabled services, support for International Fine Cocoa Research Center, redraft of the National Innovation Policy, assessment of Alutech Industry Initiative, proposal on steel pan manufacturing industry for export. In addition, the EDAB has worked extensively on policy areas related to Vision 2030, port siting and relocation study, renewable energy and energy efficiency, waste management, strategic plan for the agriculture sector. The record of most of these activities is available on the website. These submissions notwithstanding, there remains a large volume of work which is incomplete, and I am acutely aware that several persons remain with a lack of progress on their ideas and proposals. Parenthetically, I, together with 3 other members of the advisory board and other independent professionals, were appointed to a committee to review wholly owned state enterprises. That work, which covered 44 enterprises as well as TSTT, was completed in 6 months and the report submitted. My own expectations of high-level engagement followed by swift implementation on these and other policy issues have not been realized. Working within the public service environment requires an acceptance of a certain pace of work and a degree of patience with which I am clearly not blessed. Others better endowed with these qualities may succeed where I, by my own standards, have not. I thank the government for giving me the opportunity to be of service, which I and all other members gave in the spirit of volunteerism and wholly without compensation of any kind. Mrs. Camille Robinson-Regis, Minister of Planning and Development, was always accessible, and whenever her pressing duties made it possible, gave her time and personal support to our work. Mrs. Paula Gopee-Scoon, Minister of Trade and Industry, has also been supportive of our work. I would also like to thank my fellow members of the advisory board for their tremendous support and advice, the staff of the Secretariat, Mr. Thomas Bermudez and staff of the IDB, the UNDP, the EU delegation, and the ambassadors and staff of the embassies of China and Japan for their support and encouragement. The business community, especially Ronald Hines and Gabriel Faria, the CEOs of various government agencies. Thank you, ma'am. Just to say, this is what Mr. Farrell said from his own mouth about his resignation.
You do me now, right? Yeah. Honorable Senators, the question is that this Senate do now adjourn to Tuesday, the 27th of February, 2018 at 1:30 p.m. Those in favor say aye. Aye. Those against say no. The ayes have it. This Senate now stands adjourned to Tuesday, the 27th of February, 2018 at 1:30 p.m.